Yes.
I beg to mention item number 18 of today's list. 18. Mr. S. Chakraborty, Angus Council is out of station. Maybe pass over for the day, my lord.
Wait for your turn. We'll just see. We'll pass the order, but wait for your turn.
Made to also. Item number 15, my lord. This is a personal appearance, my lord. Today I am filing our affidavit, my lord. That may be called on record, my lord.
You are filing or you have filed?
Today I am filing, my lord.
Let the matter come.
Oblige, lord.
The personal appearance, the persons concerned are here.
Yes, my lord. They are coming, my lord. Oblige.
May I please, sir? I beg to mention item 19 of it. In this case, what happened? We have misplaced the file, and we have asked my friend to
Hold on. Yes.
May I please, your Lordship? Lordship, with regard to item number 10, Lordship, I have misplaced the file, Lordship, due to which I need some accommodation for today, Lordship. I have got it today morning only.
We'll pass the order.
Lordship,
Wait
may
for
I
your
fix
turn.
it out? Lordship,
Wait for your turn.
Lordship.
item 50.
Pass the order. Wait for your turn, Mr.
Yes,
Seth.
yes, sir. Problem.
Let the matter reach.
A second bail application, my lord, earlier rejected, my lord. The only ground, my lord. Actually, I am the owner of the vehicle, my lord. And in fact, my driver contacts with the, my lord, the persons to carry these things, my lord. And let the applicant case there may be call for if your lordship pleases.
Mr. Goswami,
Lordship.
this is
No.
from Bhogra.
Bhogra Primary.
Not much. So next Monday,
Lordship.
not next Monday, next Friday.
Lordship.
Can have it by. Okay.
Can it be on my Friday, 7th of August, my lord? Monday, my lord. Okay.
Yes, Mr. Goswami.
Lordship.
I am obliged, my lord.
There is a personal appearance of the chairman of Karimganj Municipality Board. For the Karimganj Municipality chairman. Are you sure?
Yes. If I'm not wrong.
They will give it. They will give it. That's why they have approached me.
Okay. But it's too late now because the second round of the
Yeah. I know. He should have filed a contempt.
Uh,
They delayed.
exactly. That's why he came for second round. Statement. As a document is an easy. No. It's just These 17 lakhs, 60,000. Total these will be 12 lakhs. আমি তো হিসাবটা করে দেবো এই ডিটেল আছে নাকি
Yes, from the Provident Fund Commissioner, Mr. Kapoor, tell us. What action you have, you are appearing for PPF functioner, right? Are you in this matter? Are you appearing for the respondent PPF? You are appearing for respondent number 4 or not? What action you have taken?
Regarding the payment of PPF provident fund.
You have filed an affidavit.
Yes, madam.
What you have stated? For the employees of this particular,
The paragraph 2.
you have said that for the period from January 2011 to June 2013,
Which have not been deposited by the city statute.
Karimganj Municipal Board did not submit the or did not deposit the PPF share.
Yes, madam.
What action you have taken?
That instruction. I have.
What instruction now? You have filed your affidavit, you don't have the instruction of what?
No, no, madam, with regard to his dues, madam, we have said that.
It is due since 2011 to 2013.
Action.
What action you have taken since 2011?
That, madam, let it be.
Why this leniency? Because they are poor.
No, no, no.
Then you have to
That's why
pay,
litigation
then you have to pay for your side. You don't know what action you have initiated?
Against the.
Mr. Secretary, kindly tell us. This is your affidavit.
Yes, madam.
You are totally silent. Why? Your nexus with the authorities. They are in Karimganj Municipal Board.
And let it be taken after some time.
No, 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 Mr. Secretary, now itself. Whatever you do now, otherwise the commissioner will be here. What kind of affidavit is this?
Madam, we have.
They are defaulter from 2011 to 13 and you do not know what action have been initiated. He has given his share. They are doing the same thing with the tea estates. All the tea laborers, they are paying their share. Will you be able to give us the data? How many tea estates in the Assam are a defaulter?
So for tea estate, there is separate provident fund.
We know that. That's why I'm asking you. Will you be able to give us the data? There are a large number of cases pending, obtaining stay orders, and the poor laborers are dying there. Because it is you, you are not looking after the things well. Yes.
Yes, my lord,
Why?
regarding,
Why this is so?
my lord, the provident fund
You
amount,
just pay from wherever you pay, we do not know.
my lord, I have given a sheet, the provident fund pay has been already been paid to
To whom?
this petitioner.
When? When did you pay?
My lord, the first page on 39/2019, he was paid 70,000.
First of all, tell us when did he retire?
He retired on 31st of January 2018.
He retired on 31st of January 2018.
18.
On the date of his retirement, what was due?
The gratuity money, that was not, he was the accountant, but he was also not sure about this news. That is why there is no mention in the repetition, earlier repetition.
It may not
Although
be
it has
there.
been calculated.
So, as you know, as per the pension rules,
Yes.
you have to take
It
all
has
the
been
relevant
calculated.
material 6 months prior to the retirement of the incumbent.
Yes,
So that means
it's his gratuity money was 12,29,307. And leave salary was 5,32,700. And his PF was earlier paid.
so
So
out of this,
out of his the total dues were 17,62,707 rupees. Out of this, we have already paid 4,70,000. Now the total dues till date, as of date, is 12,92,007 rupees.
pay him by 14th of August.
My lord, the only
We do
problem,
not know.
the only problem is
We do
the municipality is running short of.
We do not know because you have to make budgetary provisions, right? You are making budgetary provisions for payment of salary and everything.
The problem is that the regular salary of
Now, what
the,
will happen if the petitioner dies?
within 3 months,
do
within 3
not know.
months, within 3 months, matter will
Do
be.
something. He has retired on 31st of January 2018.
He knows it because he was the only
We are
accountant
not
of
on
the,
that.
he was the accountant
not
of
on
the
that.
municipality.
We are not on that.
He knows the
Hey.
condition of the municipal
We can
rules.
consider your prayer within a month. If you pay. Today is 27th of July, pay by 27th of August.
At least 2 months because the
See, you can
certain,
understand, this is not a 1 year, 2 year.
I can understand. He joined,
January 2018, and we are in end of July 2023.
that is true. I can understand. That is why I am also told that they are
Don't
willing
make
to
such
pay.
absurd prayers. You know what to do. You are a seasoned council, right? Wherever they want, we do not.
At least 2 months, they
2
will
months
clear
is
the entire.
quite a
dues.
long time. 2 months is a quite. Considering that he retired on 31st of January 2000.
But one thing also that he has
When
not
did he file
approached
this
in
petition?
contempt petition also. He has not
This
filed any
petition is
contempt.
pending since. This prayer could have been 2 months, could have been considered. He filed this petition in August 2022. Notice in this case was issued on 22nd of August 2022. And this prayer could have been considered 2 months, 3 months in September 2022, but not now.
He knows the condition. He also knows the condition. That is why after the new chairman joined, he has paid 2 lakhs, already paid 2 lakhs of rupees. The money, if it is given in a such huge amount at a time, the other workers will.
Okay. You on time, pay him 7 lakhs by 27th of August.
My lord,
The remaining amount,
within 3 months. my lord.
no.
Then 2 months.
We'll see. Everything has to be closed. By that time.
My lord.
Yes, let him enjoy the puja. So pay him. What's the name of the chairman, chairperson?
Chairperson is Rabindra Chandra Dev.
Today ordered it at 14/06/2022. Chairman cum chairperson of the chairman slash the Karimganj Municipal Board. Such and such is personally present. Matter pertains to non-payment of pensionary benefit to the petitioner. Who retired from service on 31/01/2018 as junior assistant of the Karimganj Municipal Board. It is placed before the court that as on date 12,92,007 is payable to the petition towards his gratuity money and leave salary. Council appearing for the chairman Karimganj Municipal Corporation. Submitted that such retirement dues shall be payable, shall be paid by the Karimganj Municipal Board to the petitioner within a period of 2 months. Considering the fact that the petitioner retired from service on 31/01/2018 from Karimganj Municipal Board, the respondent authorities in the Karimganj Municipal Board by way of demand draft shall pay an amount of rupees 7,00,000,000 the account of the petitioner on or before 25th of August 2023, list on 28th of August. Chairman.
Hello, bless.
That's approved. Yes, he will appear again on 20th.
My lord.
Obliged, my
My lord, may I clarify, my lord, with regard to that, my lord, action has been taken, the amount not deposited by them.
We don't know. Tell us on the next date.
For implementation of party, item number 2.
On the last occasion, in the absence of the CGSC, the increment could not be. The CGSC is there, madam.
Or Mr. Mazumdar, counsel appearing for the petitioner. Disbursed. Anonymous. You are appearing for whom?
That's not key. Opposite party. Only the, only the.
Mr. C.S. Hazarika. Petitioner slash applicant. For the opposite party numbers 1, 2. Mr. Rekha. For the opposite party number 3. NMS A. Gayan, Planet CGC. 4 and 1,
only for, could you please take?
2, arrow 5 backward. CGC. The applicant herein filed the connected writ petition being in WPC number 3132/2016. Praying amongst others for their daily wages, paying for the members of their association's daily wages as per the provisions of the Minimum Wages Act 1948. And further, to regularize, absorb their services as security personnel of the respondent number 3, Oil India Limited. which is presently pending for adjudication. That is application. That is interlocutory application. Petitioner of said application in the such and such as applicant. Have prayed for implement of Secretary, Ministry of Labor and Employment, Government of India, New Delhi, as well as Commissioner and Secretary to the Department of Labor and Employment, Assam, Dispur, Guwahati, as respondent numbers 4 and 5, and the connected WPC number 3132/2016. You want to file any objection? Or you have any objection?
Sometimes we'll file our reply.
Ms. Segayan, Planet CJC, and Mr. C.S. Hazarika, Planet J. Assam, Government Officer, and Mr. Ravi Rikiba, Standing Council for the Oil India Limited, have accepted notice for the opposite parties. Notice to returnable by 11th of August, 10th of August. Sorry. Don't make it 10th, make it 17th of August. Objection, if any, shall be filed by the opposite parties on or before 11/08/2023, having a copy of the same in the council for the applicant/petitioner. Let's start. Applicants shall have requisite extra copies to such and such and such on or before 28/07/2023. Publication after the necessary acknowledgement in that regard. Okay.
May I please, Your Lordship. Also, in this case, what happened, Lordship, petitioners twofold of prayer, Lordship, one for a year salary as well as the another for retirement benefits, Lordship. In respect of retirement benefits, we have contended in our affidavit that he is petitioner is entitled for his wife, husband, Lordship. But Lordship, on occasion, last occasion, Lordship, while passing the order, Lordship, direction was not made by this honorable court. That direction to the Oil India Limited to release the pensionary benefit of the husband of the petitioner's husband. Also. Since direction was not received, they are facing difficulty to release the, because the petitioner husband was missing from 2015, Lordship. And
When the police case was filed?
More than 8 years.
When the police case was filed?
2015, my lord.
With regard to the missing of the husband of the petitioner,
My lord.
when did she file the case before police?
2015, my lord.
What is the report of the police?
Yeah, I have enclosed that. My lord.
When-
Before your lordship, I'm sure. My lord, I'm giving the details, my lord.
One PDP fighting file on 11/2/2023, wherein the police report is annexed as page 41. Lordship. We have
I
received
have
on
enclosed the
11/12/2023. Lordship. 11 or 16, Lordship. I read a petition.
My lord, I filed an affidavit, my lord, on my lord,
report, 15th February, my lord, enclosing the report of the up-to-date status report of the my lord, police report. my lord. May I submit one thing, my lord? Your lordship, please to peruse the order dated 19/5/2023, my lord, passed by this honorable court, my lord. There it was mentioned, my lord.
Mr. You do one thing,
My lord,
immediately file an application for implement of Commissioner Secretary Home Government of Assam. This police report needs to be verified.
my lord,
So, listen to us. Once we get the report, we'll immediately pass that order for your SLD, because that you lose your complaint sometimes on
my lord, supported by affidavit, my lord.
5/4/2015. We cannot do that.
My lord, I have enclosed another report, my lord. That's why I'm saying before lordship.
We need to get it verified by the Department of Home. So file your application. Difficulty is we cannot make the parties. Earlier, we used to make the parties considering the requirement by a court's order, but it is difficult for incorporating them in the data. That is why you have to file an application.
My lord, may I pray your lordship? This honorable court has already accepted that report, my lord.
Is it?
Yes, my lord.
Yes. Data when?
19/5, my lord. 19/5 order, my lord. Your lordship order, this honorable court order 19/5/2023, my lord. The petitioner filed an affidavit in the matter of so and so, enclosing there is a police report in respect of so and so about the missing of the petitioner husband since so and so. It has further been mentioned in the inquiry report that during the inquiry, the husband of petitioner noticed, taking into account the above, as 7 years have elapsed on 9/4/2022, the London appearing court on behalf of the Oil India Limited is directed to apprise this court on the next date fixed as to what benefit the petitioner would be entitled to in terms of with the Oil India superannuation benefit. They have apprised this court, my lord, that certain amount is they are entitled to, my lord.
Okay.
Next, my lord, your lordship find that 5/6, my lord. Pursuant to order dated so and so, the learned standing counsel for the Oil India Limited has submitted that the petitioner will be entitled to certain amount, and list showing such entitlement has also been produced, a copy of which has been served on to the learned counsel for the petitioner. The learned counsel for the praise for and is granted 1 week time to have instruction on such list. In the meantime, the respondent Oil India Limited shall bring on record the aforesaid document by way of affidavit. They bring it on affidavit, my lord. Last order, my lord.
Yes, Mr. Kalita, what is your, Sharma, you are appearing?
Yes, Your Lordship. Yes, Your Lordship.
Now just tell us what is the amount payable to the petition?
If Your Lordship will see the additional affidavit, the amounts I have categorically stated by way of a chart.
Amount has
The-
been finalized, my lord, but statement has been given.
Where?
Page 79, running page 79 of the additional affidavit file.
You have filed affidavit when?
And it was filed on
16th of June, Lordship. Saroj Kumar Deka. Running page 79. We have provided the entire details of the amount that is otherwise payable to the petitioner's husband.
Mr. Sharma,
Yes, your lordship.
that is, I think so, case 79.
79 running in place, 79.
Now, in that case, Investment Provident Fund, your share,
Yes, lordship.
that is from, he joined his service on 22nd of June,
Yes, your lordship.
and why 31st of March 2006?
It was till that day he had worked. After that, he was not there.
Then gratuity for the same period.
Yes, lordship. Because after
Now-
that, he just disappeared and now. no
Now
longer
this
there.
1615
Yes, your lordship.
per month, you are paying pension per month?
No.
Since his date of joining?
Yes. So this is a pension scheme. Under this pension scheme, the amount 1615 we are paying per month.
What will be total amount?
Lordship,
Under this particular heading, what will be the total amount?
that we have not calculated.
Give us the calculation,
Yes, lordship. That,
May I play this, madam? They simply,
right?
yes, lordship.
And in the second, total accumulated fund under the superannuation benefit scheme.
Yes, this is a different fund, All India's fund.
Definitely, this is from All India's fund.
Yes, All India's fund.
This is also again from the date of joining till last date of working,
Yes, lordship.
right?
Yes, lordship.
This unclaimed wages
Salary, his
This is-
wages.
for the entire period from 22nd of June 1984 to 31st of March 2006.
Yes, lordship. So only thing is that 1615 total computation,
You
lordship. one
file
side.
and additional affidavit along with the total charge
Yes, lordship.
payable to the petitioner husband.
Husband.
Now, the report has come, we'll pass the necessary order on the next date.
Yes, lordship.
But
Only one legal fiction that is disturbing us. Section 108 of the Evidence Act says if a person is dead or is not to be
Missing.
found for missing for 7 years, then there has to be a declaration. Now the declaration will that he is dead, because why I'm saying so? I pay the money to the wife now. Suppose in an uncertain situation, the husband now turns up and he says, I have got no relation with my wife, I want my money. Then All India will be in a position as to how to go about it. So there has to be a declaration of death.
declaration to be given by whom? That's the reason we are making the Home Ministry a party. That is the reason.
I think it is the civil code.
no.
I don't
Because
think so.
some evidence issue
On the
will.
line.
Probably
I'm not sure, but I'm just thinking aloud and sharing that with your lordship. Because that is one concern we are facing. Today I make the payment because we are not saying that we will not make the payment. In fact, I have already submitted. We'll pay,
Not
but
on that. What will you?
a declaration has to be there.
It's in the process is. We'll calculate this amount
Yes, I'll do that.
and we'll deposit in a particular account by which it will accrue interest. See, by not paying this amount,
Mhm.
either to the
Yes,
husband of the
yes. Yes, I
petitioner,
understand.
lost the interest for all these years.
Yes, yes,
It's
yes.
a huge amount.
He's in fact saying interest.
But I'm claiming interest also, madam.
His claiming interest is different, but that will accrue only after 7 years.
Yes, yes.
And you have lost your affair relatedly, so it is only on
Just-
January 2003. So no
Yes,
interest as
23.
such. So what will happen if against this individual head, if you keep this money, not only for this particular husband of the petitioner, but for all of your employees, what will
Correct,
happen?
correct, lordship.
It will accrue interest.
And it
The
will be
person, while it will be given to him, he will earn that.
correct.
That's how that amount goes out. That's what the system in our high court. If some amount is deposited with the registry
Yes.
for someone in any accident claim or whatever claim, the first thing it is deposited straight away to the account so that it gets interest.
Correct.
And that money, along with the interest, is given to the concerned incumbent when it is passed, order is passed by the.
It's beneficial for him.
Absolutely.
Absolutely beneficial. And beneficial for the employer also, because he has
Both
already
way.
paid the money.
Both way, and it will accrue a huge amount. Now, if that amount would have been calculated at that stage, that's it. So
Maybe more than the principal amount sometimes.
maybe possible. We do not know because it will be a huge
I
amount.
fully subscribe to your lordship views. Yes. That we can always do.
See, the providence is that you have to have a declaration.
Yes.
Till such declaration is there, whether under the civil laws or whatever,
Yes, yes.
that account, keep it in an account.
We are agreeable to that. We are agreeable to that.
So do one thing, you give us that thing by Next Friday?
next
It's
Friday.
not a huge thing. It's not possible. From the, you are serving here or at the Duliajan?
Duliajan.
So from the accountant Duliajan get it,
Yes, Lordship.
not much. Right? And the,
On 11th of August, Lordship.
Maybe delayed, so may early, so also.
no.
This Friday I'll be
Today is
out.
27.
Yes, Lordship.
You file your affidavit by 7th.
7th, yes. And Lordship will have it on 11th.
We will have it on 9th,
9th, I'm out of station, Lordship.
10th.
Yeah.
19th, not possible.
11th, Lordship. That is why 11th.
Okay, but file your affidavit by 7th.
That
so
I will
Mr.
do.
Maheshwari will also will to go through the amount,
Yes, that I will do.
right?
Yes, Lord.
Will do.
Obliged, Lordship. Obliged.
The respondent Oil India Limited shall file an additional affidavit, hard mistake, Maheshwari, specifying the total amounts
Also, will specify that EPS.
payable to the husband of the petitioner against each head. 1 year provident fund, 2 gratuity, 3 pension under employee pension scheme within bracket EPS, 1995, 4 total
Superannuation benefit. It's already there.
total accumulated fund under the Oil India Superannuation Benefit Scheme Fund. And unclaimed wages. For the period of date of joining of the late husband of the petitioner. Babul Hazarika. He was absent since when?
31 31/3/2006 is the date that has been taken by the company. After that, he was absent. 31/3/2006.
Okay.
Lordship will find it in that remark column.
That we have
itself.
seen. No,
Yes.
no, in the affidavit, first affidavit also.
Yes, Lordship.
Otherwise, it's a Babul Hazari collection, huh? Mosdur under grade 1. Confirmed by the Oil India Limited on 22/06/1985. Okay. Remain absent from his duty. Effect from 01/04/2006.
My lord, may I pray one thing, my lord? This is interim order, my lord. Matter will be heard again, my lord. On
You want financial benefit, right?
no, that is
Nothing
my
else.
this court,
Wait for
honorable
it.
court advise us to take the money, then argue the matter, my lord.
We'll see to that. Money should be safe when you should earn interest, that's all.
This will be expressed by this honorable court.
Self-held additional on or before 7th of August. Serving a copy of the same from the council for the petition. List on 11th of August.
May I pray the my lord 14, my lord, maybe 14 August, 1/4. Monday, my lord.
1/4. Okay. 14th August.
Oblige you.
Yes, sir.
Yes, Mr. Mahmood.
My lord, can you see the last three orders? Nearly 20 lakhs of money to 19 teachers, house rent, medical allowance, and grade pay, etc. Though
Yes,
bill
Mr.
has been
Sharma.
prepared in the year
Lordship,
What is
2014.
happening?
Lordship, in terms of this honorable court's order, we have filed our affidavit to bring on record the order whereby inquiry committee was constituted
Where?
to ascertain the authenticity of the claim of the petitioner's lordship.
Where is this?
This is on record, lordship.
When did you
Filed by-
file your affidavit?
It was on 26th of June. 26th of June this year, lordship, 23.
26th of June.
Lordship,
Who filed it?
Director, Suranjana Senapati. The annexure 2 is the order whereby an inquiry committee has been constituted to ascertain the authenticity of the claim of the petitioner's lordship. Thereby, and subsequently that inquiry committee
You filed an affidavit on?
on lordship 26th of June. Now may I place the inquiry report, lordship?
Just a minute.
Number 105 and annexure 2 is the order.
You have constituted the inquiry committee.
Lordship.
What is the report now?
Now, lordship, I have just now placed the report, inquiry report, lordship. It is. The inquiry was held on 1st of July 2023, lordship. This is the inquiry report.
It is finance, General of Finance.
Lord, I have submissions.
Please. Yes, Mr. Mahmood, please carry on.
My lord, they have filed affidavit on 23/6/23. Lordship may kindly see the para 5 of their affidavit, page 101. That dependent at the stage of controverting the statements and amendments of the petitioner made in the petition paragraph wise.
Now, can you tell us which are your concerned treasury office?
Mongol.
All are Mongol.
Yes.
Now, which are the petitioners who have retired from service and on which date they have retired?
Yes, only
Can you
one.
give us a chart? The date of joining of the petitioner and the date of return of those persons who have retired. And the other petitioners, when did they join the service?
We have annexed their appointment letters.
We have to go through everything, or you will give us a short manner. When did they join?
That is, there is no such dispute at all. All are teachers, admittedly they are teachers, some of them
We are
retired,
not saying, Mr. Zah.
few are still working.
When did they join? That's what we want to know. When they have joined their services.
That is the question, but here, my lord, after
Mr. Mahmood tried to
I
understand.
have understood,
Says
but
only
that
to
that
ease
is
your
not
case.
with us.
Mr. Nayak? Lordship. I think there was some notes in the this record that no affidavit in opposition has been received from the Treasury Officer Mongoldoy. Last note of the registry.
The treasury officer did
Now,
not pay, we have,
these petitioners are claiming some benefits which not been paid to them. Relates to house rent allowance. Then grade pay, dearness allowance. Now, the treasury officer, Mongoldoy, and out of that, some 5 teachers have already retired from service. The Deputy Inspector of Schools and the DEO, it's a DEO, not the Deputy Inspector of Schools, found it difficult to ascertain the amount because there is no relevant records regarding non-payment of that. Except saying that there is no budgetary provision for payment of those. The DO could not help out the directorate to determine the amount. So the director constituted a committee to find out the difficulties. Now, Mr. Sharma has placed a report of the committee. Not there. No documents are available, no records are available. But the thing is, with regard to the amount payable to each of such teacher serving in each of the district, whether under the DEO or the DI or the inspector of schools, the finance department keeps a record, keep the data, because it is the treasury officer to whom the bills are raised by the DDOs. Kept in record. So we want to know from this particular treasury officer, say for a particular period, what was the salary component of these petitions? Or say 10 months, 12 months. We wanted to know from Mr. Mahmood when did the petitioners join their services. This is because if any benefit to be given to the petitioners under the MACP scheme, counting their periods from 10 years or 20 years, they would have been entitled for certain kind of benefit. From the date of their increment under the MSCP, again the pay scale will change, right? Hopefully, Mr. Mahmood will give the date of
We
joining. of
have
the
next
each of the
appointment
petitioners.
letters.
Appointment letters will not do. You might have joined after 2 months. How do you know?
But
Nobody
all
is
this, my lord, I
challenging,
understand
Mr.
that.
Mahmood, nobody is
But
challenging your
lordship
appointment.
kindly consider, this is the
Date of
case of
appointment
2018, and today they are saying records are not available.
They are not saying, we are saying. So what we have to do, find out from your schools, your service book, the date of joining. That's easy process.
That may
Right?
be
We
done.
want to help you. If you do not want to help you, we can pass
That,
different
my lord,
orders.
I may submit to us, there is no problem. But thing is this, my lord, this mega amount, para 19, we have written the reason. Kindly see,
Let first
the
decide.
treasury officer has created all this problem.
So
For
for a
his own
particular
interest.
period, after coming to know from Mr. Mahmood the date of joining of each of the petitioners, for a particular period, we will intend that the concerned treasury officer will give us the details for a particular year, the amount of salary they received. And the components will be there because the concerned DDO, while determining the salary,
So that is my concern, Lordship. These are great pay, DNS allowance, medical allowance, HRA. These are only part of the total salary, Lordship.
that's right.
If the salary is not area, how can this great pay become area, Lordship?
No, it may so happen, while determining.
There may be wrong calculation, but only the HRA part will remain area, great pay will remain area. That is bit, Lordship. Not understand.
You have other way. Mr. Sharma, and you can do that. The concerned DDO, you can ask from the records from the concerned DDO, the headmasters
From
of the
finance
concerned DDO.
department, what I can do, Lordship, I can try to ascertain from the treasury officer or ask for some record. If he has some record
No,
in
because
respect of the petition.
necessarily whatever the bills raised by the DDO,
Yes, Lordship.
that has been given by the treasury officer. Now, if there is some, as we have seen the budgetary allotment, concern for the budgetary allotment to us will be only for the purpose of areas, not for other purpose.
Yes.
Now, assuming the petitioners got the benefit of MSCP. Any benefit of MSCP, their increment will be joining in his salary component. Automatically, it will increase.
But Lordship will kindly see the payer, Lordship. Why the petitioners shall not be paid their outstanding arrear salaries and allowances to rupees 19 lakhs 96,000 so being arrears of substantive allowance like great pay, DNS allowance, medical allowance, HRA, etc.
See, possibly they were at a fixed salary for a particular period. We do not know. They might be in a fixed salary. So in that case, that is why that particular payment of salary component from the treasury officer will just give us a lead, nothing else. Will just give us a lead, what was their salary at that point of time. Everything will raise only when the petitioners gives us the date of joining in their respective schools.
Lordship, I will try to obtain, but I'm not sure.
No, we at this stage we're not sure, but only a lead was the amount that was paid, the component that was paid, the salary that was paid. That's what. If it's a fixed salary, nothing will
Lordship,
come.
I will try to obtain whatever record is there with the treasury officer in respect of the petitioners regarding their scale, Lordship, scale plus other allowances, Lordship. That will
Give us
clarify.
by
My
next.
lord, Lordship, I have also placed another communication dated Lordship, 26 July. Lordship, as per the suggestion of the inquiry report, Lordship, the BO concerned has resubmitted the proposal to the director. But on verification, there were number of anomalies, Lordship. Lordship may kindly peruse this communication dated 26 July 2023 issued by the director to the block elementary education.
Mr. Sharma, Mr. Nayak, can you tell us why all these things are happening with the teachers only? Why?
Because Lordship, in education department, there are so many authorities, Lordship. That is one issue, Lordship.
And although the petitioners has come together, Lordship, but the cause of error, this is not a common cause of error, Lordship, otherwise. Some of them are.
We'll do the needful.
My lord, one prayer, my lord. I do not understand. Their officers have prepared the bills. We have submitted those bills. Now they are contradicting. What action they have taken against their officer if these are false? Or what action have been taken against the petitioners? If the petitioners have produced a false and fake documents, they are also liable for legal action.
Mr.
Now,
Mahmood, you are from which place? From Dhuri?
no, from Dorong.
From Dhuri.
These petitioners are from Dorong.
Anyone from Borpeta district? Okay. If you go to move around in Borpeta district and talk to
So
people.
they do not take any action
Mr.
against their officer and
Mr.
now
Mahmood,
contradict. It
listen
is
to
very
us.
surprising.
There's
4
a-
teachers, 20 teachers, 19 teachers, 20 lakhs money, less than 20 lakhs. There is the objection.
You want to say very small amount?
A small amount in respect of, because 19 are the
Let us-
petitioners. So 19 lakh 96,000. So less than 1 lakh per person. And bill is prepared by their officer. Whether officer has prepared the bill without showing, observing all the documents. And whether in read court can do compare that whether legal or because officers have prepared. If officers have prepared wrong, then he should be punished. If we have produced false document, we should be punished. Now they are raising this issue. Last time some matter is sent to budget, finance, they will pass the bill and we will pay immediately. Can you see the last few orders? Today now they are saying two different things. The last occasion they said we will pay. Treasury officer is the only responsible. Others, that we have mentioned in para number 819 of our petition. So every time they will come, these 4 teachers, one already dead. Others are also, many of them are retired already. When they will pay? After their death. If the bills are false, let the action be taken. Who are responsible for these false bills? If no action is taken yet observing, then the court should ultimately reject their claim. Just now that the such sort of submission is not acceptable because they cannot play with these 4 teachers.
Who have retired from service? Which petition?
Yes. Otherwise, you have met, yeah. Roshi, can you see page 8, para 3? The petitioner requested the petitioner number 17, namely Idris Ali, petitioner number 18, Shamsul Haq, petitioner number 15, namely Nur Muhammad, petitioner number 14, namely Suraj Jamal, petitioner number 16, Sheikh Abdullah are all retired teachers.
Oh, just a minute.
Petitioner number 13, my lord, he is dead. Her husband is dead, now wife is the party. 13. Husband was Abdul Malik. And as per my report, one Mukunda Sharma, he has already, after filing this case, he has retired.
Or Mr. Memo Mohammed. Counsel for the petitioner. And Mr. P.M. Sharma, standing counsel, Department of School Education, for the respondent numbers 1, 3, 4,
Respondent number
and 6. As well as Mr. P. Nair, standing counsel, finance,
2 and 5.
for the respondent numbers 2 and 5. The petitioners herein 18 in numbers stated that they served as assistant teachers in various lower primary schools under Dolgaon Sialmari Education Block, the district of Dorong, and that they were not paid great pay, dearness allowance, house rent allowance, etc., for which bills were raised by the Block Elementary Education Officer, Dolgaon Sialmari Education Block, respondent number 6, amounting to rupees 19 lakhs. $96,106. Dearness allowance, medical allowance. But not considered by the other respondent authorities in the elementary education department. Hence, this writ petition by the petitioners, which interest at the rate of rupees 9% per annum from the day when their amounts became due till the date of payment of actual amount. While filing this writ petition on 12/10/2018, swearing an affidavit by the petitioner number 1, Nurjamal Hussain, thus placed before the court that petitioner numbers 15, 17, and 18 already retired from service Whereas husband of the petitioner, number 14, expired.
Or should it be 13?
So not 14, 13. 14, 15 retired, isn't it? 14, 15, 17, 18 retired. 14, 15, 17, 18 retired, and 13 are wife. That's all. Husband of the petition number 13. Were also already retired.
Of them have also retired after filing the case, but their exact names I have no information at this.
No, the husband of the petitioner was a retired employee or
Retired
was
employee, thereafter he died before
and the
receiving
husband of the
this
petitioner
allowances.
also retired. From the cause title, and the date of filing of the present petition, it can be seen that petition number 1, 2, 4, and 12 have also retired from service. To ascertain the claim of the respondent petitioners, the Director of Elementary Education Assam constituted a committee, a 3 members committee on by order dated 15/06/2023. Now, the said committee after hearing the petitioners, the other authorities, including the Block Elementary Education Officer, Dolgaon, Selmari, Dorong Education Block, as well as Block Elementary Education Officer, Masbat, Udalguri, after hearing the petitioners on 01/07/2020. Submitted its report. With the suggestions that the Block Elementary Education Officer Dolgaon, Selmari,
My lord,
District,
one
Dorong.
letter is with me. Here the treasury officer says he did not submit the bill and this kindly say, he has admitted when budget would come, we will pay, and in that manner it is written. Kindly see this letter. Of the
Should be instructed to resubmit the arrear salary proposal upon authenticated verification of arrear salary of each of the individual petitioner separately, and in doing so, should take up the following supporting documents along with the proposals. namely 1, 2, 3, 4, following took up the supporting documents to be submitted to the each of the proposals. D 1, 2, 3, 4, namely 1. Fresh area salary proposal along with non-rail certificate countersigned by the BEO concerned and the Treasury officer. 2. Due and drawn statement against its employees with remarks. 3. Supporting documents of area salary. 4. Junior basic training pass certificate and appointment letter. 5. Enhancement of fixed pay and date of the effect. 6. Suspension order and regularization order, which condition, if any. Which condition, if any, nearly. 7. Allowing SCPS/MACPS order. And 8. The status of claim of the petitioner Mukunda Sharma, petitioner number Mukunda Sharma. For his area salary, or it was the claim of his area salary. Verifying the period from the attendance register as well as working certificate to be furnished by the concerned headmaster with area salary proposal. During the deliberation of the matter, Mr. P.N. Sharma, Extending Council, Department of School Education, placed another communication of the Director of Elementary Education Assam dated 26/07/2023, informing the Block Elementary Education Officer such and such, response number 6, that the claim of arrear salary paid to be paid to the petitioners. The said BEO have assessed the amount wrongly, giving certain examples. Giving certain examples like in respect of petitioner number 7, Gita Sarkar. Gita Sarkar. The though she passed her junior basic training during 2003 as per the certificate, but the arrear salary was considered for her by the BEO the time scale from 07/10/1997, though there was no such order allowing time scale to the said petitioner from 07/10/1997. There are certain other anomalies with regard to the petitioners regarding such assessment of area claim of the petitioners. It is seen that claim of each petitioners are different than the other petitioners. By filing an additional affidavit, the petitioners on the next date fixed shall apprise the court the date of joining of their respective schools after their appointment order, date of passing the junior basic training by each of them with the respective JBT pass certificate. And their respective along with their date of birth really, with HSLC pass certificate. Select. And their respective claims against each of the component towards grade pay, DNS allowance, house rate allowance, and medical. Such additional affidavits by each of the petitioners shall be filed on or before 19th of August, released on 22/08/2023. Copy of the communications of the Director of Elementary Education Assam, dated 26/07/2023, along with the report of the constituted committee by the Director B. Assembly, be kept as a part of the record.
Each of the petitioner will have separate additional review.
You file individually, otherwise it will be difficult because your claims are different.
It's
Since the matter is of 2019, otherwise we have passed an order to file separate writ petitions. We are doing that in all the new writ petitions. But since it's an old matter, we are not passing that order. So file your additional affidavit individually so that we can know the claims. Yes, Mr. Hazarika.
Yes.
Pertains to interest upon late payment of
His claim for
Delayed
all such
payment of-
benefit. Yes. What is your stand?
Some pleadings are complete, my lords.
What pleadings? You are paying him or not? That's the one.
Well, my lords, there is an earlier order, my lords.
Hmm.
What had happened was the petitioner, following a penalty imposed by the disciplinary authority, my lords, he was earlier dismissed, my lords, from service. Now the allegations in
What was the direction passed earlier in WPC number 883/2012?
my lords,
Please come to page number 20 straight away.
my lords. The earlier directions, my lords, was the
Okay, page 19, last paragraph.
my lords, my lords.
page 20, para 22.
So we will do the needful. Page 19, last
The
paragraph.
matter was remanded, my lords,
Please read page 19, last paragraph.
my lords. My lords, would require justification, my lords. Now,
Do you
for
have a
subsequent.
copy of- do you have a copy of this order or not in your petition?
No, yes, I do have a copy. Thereafter, my lords, there was another writ petition, my lords.
So let us go by step by step.
My lords.
Let us read page 19, last paragraph.
Yes, my lords.
Kindly read.
Para 20, my lords.
Hmm.
Even under section 4, subsection 6 of the Payment of Gratuity Act, gratuity payable to an employee may be wholly or partially forfeited if the service of the such employee is terminated for an act constituting an offense involving moral turpitude. Whether gratuity should be wholly forfeited or partially forfeited or not forfeited at all would require due consideration by the competent authority, my lords.
Next.
Second, thereafter, my lords, right to receive gratuity is a valuable right of an employee. It is one of the minimal service conditions made available to an employee. It would require good, sufficient, and compelling reasons to deny gratuity to an employee. Since such denial would result in adverse civil consequences on the employee, principles of natural justice and fairness would have to be adhered to while taking such a decision. Therefore, in the course of taking such decision, the affected employee is required to be given an opportunity of hearing, and his case has to be considered in a proper perspective, notwithstanding imposition of such penalty, resulting in termination of service. That being the position and having regard to the observations made above, order dated so and so cannot be sustained and is accordingly set aside and quashed. Matter is remanded back to the appellate authority, that is the Board of Directors, who shall take a fresh decision regarding entitlement of the petitioner to retirement gratuity. Before taking a final decision, Board of Directors shall give a reasonable opportunity of hearing to the petitioner to present his case. The above decision shall be taken.
Then the Board of Directors passed that order.
Malas.
And there was another repetition.
There was another repetition.
Case 23.
Malas.
Yes.
The relevant portion, Malas, starts from para 20 at page 28, Malas, of the writ petition.
Yes.
May I read, Malas? In the present case, it may be noted that this court had directed the authorities to consider grant of gratuity after hearing the petitioner and accordingly was granted. In the other words, the employer had initially refused to grant gratuity, but later on the prodding of the court, it was granted. However, it is to be also noted that there is another provision under section 4, which provides for denial of grants of gratuity in respect of employees whose case is covered under subsection 6 of section 4 of the Act. Subsection 6A and B make it clear that the gratuity payable to an employee may be wholly or partially forfeited in case he has been terminated from service for any riotous or disorderly or violent act, or for an act which constitutes an offense involving moral turpitude, providing that such offense was committed by him in his course of employment. Perusal of section 4 would therefore indicate that normally gratuity is a vested right of an employee which is entitled to receive upon fulfillment of the conditions mentioned under subsection 1 of section 4. However, that vested right becomes a conditional right depending upon the circumstance in which the person is terminated from service, as provided under subsection 6 of section 4. Thus, if an employee is terminated from service on the ground that he committed an offense involving moral turpitude, which was committed in the course of his employment, the right to get gratuity ceases to be a vested right and becomes a matter of discretion of the employer concerned to grant. In other words, authority may withhold payment of gratuity wholly or partially, depending on the circumstance of a case in respect of an employee whose service has been terminated on account of commission of an offense involving moral turpitude. Therefore, from the above, this court would hold that the right to receive gratuity, which is a vested right of an employee under normal circumstance, as provided under section 4, subsection 1 of the Act, ceases to be a vested right of an employee to receive it if the nature of the termination is covered by circumstances mentioned under subsection 6 of section 4 of the Act, in which event it becomes discretionary right of the employer to grant or not to grant gratuity to the employer. Therefore, keeping the aforesaid legal position in mind, this court would examine under what circumstances the petitioner had been terminated. It is not in dispute that the petitioner was terminated from service by way of imposing that penalty of compulsory retirement on certain charges being proved, one of which involved moral turpitude. The earlier charge in the earlier order, Malats, the allegation was with regard to sexual harassment, Malats. That charge was proved. I'm reading further, Malats. Though there was other charges on the basis of which petitioner was compulsorily retired from service, nevertheless, one of the charges consisted of an activity involving moral turpitude. In that view of the matter, case of the petitioner would be covered under subsection 6B of section 4. In that event, it can be said that the petitioner would not have any vested right to get gratuity, but the right to receive gratuity would be dependent upon the discretion of the employer. As regards payment of interest on delayed payment of gratuity, same is governed by Rule 68 of CCS Pension Rules 1972, which reads as under follows. Interest on delayed payment of gratuity. 1. If the payment of gratuity has been authorized later than the date when its payment becomes due, and it's clearly established that the delay in payment was attributable to administrative lapses, interest shall be paid at such rate as may be prescribed and in accordance with the instructions issued from time to time, provided that delay in payment was caused on account of failure of the part of the government servant to comply with the procedure laid down, so and so. What the above Rule 68 provides is interest will be payable on the following circumstances. 1, when the payment becomes due. 2, and the delay is attributable to administrative lapses. If either of the conditions is not fulfilled, interest is not payable for delayed payment of gratuity. It is to be seen whether payment of gratuity was due to the petitioner. The word due relates to an entitlement or benefit which an employee is entitled to enjoy as a matter of right, and which is not dependent upon the discretion of the employer. It ceases to be a due if the employer is given the discretion to grant the same in respect of an employee whose case is covered by subsection 6 of section 4. Grant of gratuity in such circumstances becomes an offer by the employer, a bestowal of largesse, and not a due. In the present case, if the petitioner had retired from service under normal circumstances, as contemplated under subsection section 4, section 1 of the Payment of Gratuity Act, it could have been said that the right of the petitioner to receive gratuity is a vested right, and such amount will become due from the date of retirement. However, since the petitioner was compulsorily retired by way of a penalty in respect of certain proven charges, which includes a charge involving moral turpitude, the right to receive gratuity was dependent on the discretion of the employer, and his employer could grant gratuity wholly or partly. He did not have the right to claim gratuity as a matter of right and could get it if offered by the employer. Hence, payment of gratuity was not due when he was compulsorily retired, but became due only from the date when the employer decides to grant it, my lords. Respondent did not initially grant gratuity at the time of compulsory retirement. To that extent, it can be said to have been refused. However, the respondent decided to give gratuity only when the court intervened, directing respondents to consider grant of gratuity. There was no specific direction by the court to grant gratuity, my lord. In that view of the matter, this court would hold that gratuity was not due at the time of compulsory retirement of the petitioner. Hence, Rule 68 cannot be retracted, as the petitioner did not have a vested right to claim gratuity vested right to claim gratuity, and gratuity was granted to him at the discretion of the respondents in terms of section 6 of section 4 of the Act. As a consequence, he did not have a vested right to claim interest on the delayed payment of gratuity, and it was not due when he was compulsorily retired, my lords. The matter was again, my lords, remanded back to the APDCL to pass a reason order. My lords, they submitted a representation, my lords. They were speaking
this time reason order only with regard to the grant of interest in the delayed payment.
Delayed payment, because my lords, the authorities had decided to pay the amount, the gratuity, on 10th February 2016, and the actual payment
with effect from,
my lords,
from the date of his termination, that is from service.
No, my lord, from 10th of February 2016. My lord, I'll just show that. My lord, my lords may kindly have the affidavit filed by the respondent. My lord.
Just a minute. Where is 3/6/2016 order by which you have granted him the gratuity?
The speaking order.
First order.
Yes.
Pursuant to the order of the court dated 26/11/2015.
My lords, that is part of the affidavit in opposition filed by the APDC, my lords, Annexure 1. Affidavit filed by Ms. Porobi Bora Deka, my lord. Page 12 of the affidavit.
Mr. Hazarika?
Yes.
Can you show us when, after this order of the court on 26/11/2015, when did you submit the certified copy before the authority?
Yes.
That representation is something annexed, but the only thing is that they represented by paying for the interest, that is there only, that is page 22. But that representation is not there. The order of the court was communicated, but there is something else.
When? That's what you want to know.
That is not mentioned here.
Did not mention.
But I can place before this honor record here. I have the records in the other private litigations are there. I can bring up. Also, there in respect of administrative lapses here also. There the other incident was there that not being communicated to the honor record here also. They have the knowledge. A similar kind of person were granted gratuity here also.
Anyway.
Treatment was
okay. So Chaudhary, after this, what happened?
My lords,
You have decided to give, where is the order?
My lords, the order is the speaking order, my lords. That has not even been impugned, my lords, in these proceedings, my lords.
It is just from your
Page 35 of the petition. Relevant being, my lords, page 38.
39. 39 is last.
38, my lords, is important.
Because they have exercise.
38 of the writ petition?
Of the writ petition,
yeah.
my lords.
No, that's your, yes.
That's the speaking order, my lords. Now, the speaking order, my lords, second last paragraph at page 38, bottom of second last paragraph, my lords, I'm reading. Since the board of directors decided to grant gratuity on 10 February 2016, it became due from that said date only. The ultimate payment was made on 5th April 2016. Hence, I do not have any hesitation to hold that Mr. Gogoi is not entitled to interest from the, is actually entitled from interest for not from entitled to interest from the date of compulsory retirement. Now, thereafter, my lords, page 39, however, as the gratuity became due from the date of the order of the board of directors, interest may be granted from that date of such decision of the board till date of actual payment. Accordingly, it is hereby ordered that interest for the delayed payment of gratuity shall be paid to the petitioner from 10th February 2016 to 5th April 2016. That has already been done.
Mr. Hazarika, was there any challenge to this honorable, the order of the court passed on
No, my lord.
No, no, then the representation was filed.
On
Your Lordship.
31/01/2019. Any challenge?
No, my lord.
No,
You have not challenged that.
only a representation was filed by the
No, fine.
petition, Your Lordship. That is on
See,
page 40. Your
in the
Lordship.
order is 31/01/2019. The court clarified. two
He-
aspects.
He only filed one representation in respect of
Listen.
that and filing this
Listen.
present application, Your Lordship.
Mr. Hazarika, listen. The court clarified two aspects. That the interest component, delayed payment interest component is possible when gratuity is given under 4.1. When there is no administrative lapse on the part of the.
Yes, that was there. The
Now-
lapses were there. Your Lordship.
Listen, that's.
In
your
case of one
claim.
person, they had the
Second
knowledge
part.
and they arguing the case, they had not communicated that Dhirendranath Bordoloi, one person, have similar status quo was given gratuity, Your Lordship. That was in the knowledge, and that was being annexed, that particular order was annexed in earlier petition, Your Lordship. If Lordship permits me, I can bring that particular order of the
Now,
APDC, Your Lordship.
Mr. Hazarika, this court, by the order of the 31st of January 2019, clarified that if somebody service removed for the specific reasons under section 6.4, in that case, the payment of gratuity itself, it becomes may. It depends upon the employer.
And fully said.
So after the first order of the court, which was set aside and remanded back to the board for reconsideration, the board accordingly reconsidered and gave you the gratuity.
Yes.
And it was paid in your account, I think so, on 3rd of
5th April 2016.
It's very clear. It was decided on 10th of February 2016 because it has become May after the matter was remanded back to the board for reconsideration. It was considered on 10 to 2016 and it was paid to you on 5th of April 2016. Now, please come to the finding of this court passed earlier. Judgment dated in the order dated 31/01/2019. Come to page number 29. Read para 21 and 22.
Perusal of section 4 would therefore indicates that normally gratuity is a vested right of an employee which is entitled to receive upon fulfillment of the conditions mentioned in subsection 1 of section 4. However, that vested right becomes a conditional right depending upon the circumstances in which the person is terminated from service, as provided under subsection 6 of section 4. Thus, if an employee is terminated from service on the ground that he committed an offense involving moral turpitude, which was committed in course of his employment, the right to get gratuity ceases to become vested right and becomes a matter of discretion of the employer concerned to grant.
Next page.
22. In other words, authority may, which payment of gratuity wholly or partly depending on being
Tense of a case.
circumstance of the case in respect of an employee whose service has been terminated on the account of commission of an offense involving moral
Now,
turpitude.
understood. Now, for section 68, regarding delayed payment of interest of gratuity, please come to page number 31.
31.
Kindly read the last line of para 28. Page 31.
Oh, yes, page 31, para
Para
number
28, last line. The last two lines. In fact, it starts with the.
If offered
It
by
starts with, please come to para 28, the fourth line towards the right. He did not
he did not have the right to claim gratuity as a matter of right and could get it if offered by the employer. Hence, the payment of gratuity was not due when he was compulsorily retired, but becomes due only from the date of when the employees decided to grant.
Decides to grant it. Now, in your case, the employee, FPDCL, decides to grant it on 10th of February 2016. That is the reason we ask you whether you have challenged this order. And since you have not challenged this order, in terms of this order of the court, the interest component will be due only from the date when the employee decides to grant it. In that case, listen, in that case, the employee decided to grant you on 10th of February 2016 and actually paid in your account or whatever paid you directly. It was on 5th of April 2016. So the decision, impugn decision of the FPDCL regarding the payment of interest is only from that date. Where is the illegality?
And also, come to page 12 here. Page 12.
12.
Page 12.
Of your writ petition.
Of the writ petition. The order by which the order of dismissal was reduced to a compulsory retirement. Page 12. Page 12 of the writ petition.
Yes.
This is the order dated 2nd of March 2009. Accordingly, it is hereby ordered that the penalty of dismissal from service imposed on Sri Bhuvan Chandra Gogoi, former Deputy Accounts Officer, by the order dated so and so, shall stand reduced to a compulsory retirement with pension benefits. It is in partial modification of the order dated so and so to the above extent. Since a person having same status was granted gratuity, because after that it was denied. The gratuity was denied. Pension benefits, gratuity was denied. But in a similar circumstances, the gratuity was granted to a person having the same status to their office. In a case
now,
of,
see, in that case, what will happen? If you are asking that
that is create administrative access to your office.
Say the authorities in the FPDCL, while considering that aspect, have decided to compulsorily retire you, right? Earlier, there was another order. 31st of
incident was there. He is also compulsory retired. Get the gratuity also.
Things are different. So earlier it was decided that compulsory retirement. Now it was reduced to, earlier it was dismissal from service.
Dismissal from service.
Earlier was dismissal from service. And it has been changed to compulsory retirement with pension.
With
right?
pension benefits.
With pension benefits. So what are the pension benefits?
At the relevant point of time, I'm only receiving the pension. Then he asked for the gratuity. That was denied. And that the denial order was set aside by the Honorable Court.
Now, since already two courts have decided the issue, the first court have set aside the order rejecting the payment of gratuity. Did not touch with the order of pension. This order was not touched. Though you have challenged. Though you have challenged, it was the non-payment of gratuity. It was very specific period. The matter was remanded.
Challenge the order of denial. This challenge in the first writ application, he challenged the page 14. The page 14 was challenged in the first writ application. Page 14 of the writ petition. With reference to the above, I am directed to inform you that the Board of APDCL, right, Office Order so and so, dated 2/3/2009, reduced the penalty of compulsory retirement with pension benefit. The gratuity is not admissible as per Rule 40, sub-rule 1 of
No, that
CCS
is the
pension
reason,
rule.
Mr. Hazarika, we have said that is why this order was set aside by the court in the first order and directed remanded back the matter to the official to reconsider the matter.
Reconsider after hearing.
Right. So after hearing order, that order was passed. Now that was challenged in the second writ petition.
Yes.
But here the things are different. The initial thing is compulsorily retired with the pension. Your case is, since the authorities have considered your case as compulsorily retired with the pension, will be entitled to all such benefit, whatever is there under the pension component. They could not have stopped you giving him from gratuity. Now, since they have given you the gratuity for that period on giving them certain amount, now you are asking for the delayed interest
Only
for that period from the date when they are giving you the order of pension. For that, this order, the second order of the court, have clarified that you are not entitled. That's why you're asking you whether you have you challenged that order. You said no.
Only thing is, Your Worship, that
We cannot see it as a review of that order.
To
at
paying
this
interest,
stage.
only they can invoke only 68 of CCS rules, Your Worship, because it has been paid. The interest of delayed payment was
We will not announce.
gratuity
We are-
shall be paid.
Mr. Hazarika,
Because only 68 have to be exercised. They are giving me the interest
We are
for
not-
2 months by invoking 60. They already exercised it.
we are not on that. The court in the order dated 25, this is an order of, oh yes, 31st of January 2019 as page 31. Clearly stated, due only from the date when the employee decides to grant. It is not in terms of your earlier order.
Employer.
It should have been from the date of the decision taken by the authorities on this 2nd of March 2009. This order, because by this order, the APDCL decided to give you pension. And your claim is from 2nd of March 2009. It should not have been from this particular order of 12th of.
And also,
I think so.
page 32, because 4 weeks time was granted for a personal hearing. That hearing was
See,
took place,
not to-
order was passed, and in that order, 2 months interest was given by invoking 68. Your Worship.
How to remove this? Due only from the date
They
when
should
the
have
employee decides to
they should have
grant.
rejected the representation, because they have invoking 68. Only invoking 68 interest, late interest upon gratuity can be paid. Your Worship.
First of
They have
all,
already exercised.
First of all, the court came to the conclusion that you are not entitled to gratuity. First of all. Second of all, if you are entitled for the gratuity, it has to be from the date of for the interest, it is to be due only from the date when the employee decides to grant. it.
Think that
We cannot go back. We
that
cannot. we
by
cannot
by
go-
invoking what section they have allowed 2 months of interest.
Can we sit in a review of the order passed earlier by the court, since you have not challenged it?
Now, the only thing they
Otherwise, you
challenge,
see-
but he filed one representation. Your Lord. That being never been
Basically-
answered. Your Lord.
Basically, the order of dismissal converted to
Compulsory retirement.
compulsory retirement with pension.
Pension,
So
benefit,
pension means all pensionary benefits.
all pension.
The APDCL of its own said that no, you are not entitled for gratuity. That was challenged, set aside by the court, remanded back the matter, have given you this. Now, in this order, there is a specific observation that only from the date when the employee decides to grant you, because it comes under 6(4). Right? So, at this stage, we cannot go beyond this finding of the court.
And the only thing is that
Should have preferred an appeal or a review.
Page 39, Your Lord. Page 39, accordingly, it is hereby ordered that interest for delayed payment of gratuity shall be paid.
Absolutely right, because of
Because-
paragraph 28 of the judgment
Because
of
they have
30th of
exercised,
January.
because rightly, wrongly, they have exercised rule 68, Your Worship. Under what position they are paying me that interest for only 2 months, Your Worship.
We cannot go beyond this order.
Then after the Lordship kindly see the representative to me that never been answered, Your Worship. Page 40 and 41, Your Worship. Page 41 to 42, Your Worship. That has never been answered, Your Worship.
Not necessarily, not required. The finding of the court is very specific. They acted within that particular parameters.
It is not applicable in my case, but they have already invoked section 68 or law.
Heard Mr. Arpi Hazarika Learned Counsel appearing for the petition. Mr. B. Chaudhary, right?
B. Chaudhary, my lordship.
CHOW or CHOU?
CHOU.
Learned Standing Counsel for the APDCL. Standing Counsel APDCL. For the respondent numbers.
All the respondents.
We're appearing for 3 also.
My lord, he is since retired, my lord.
1 and 2. So there is submitted that the respondent number 3. The earlier managing director of the APDCL has already retired from service. Please take your seat.
Thank you.
Petitioner was serving as Deputy Accounts Officer in the APDCL. By an order dated 02/03/2009, the authorities in the APDCL not APDCL, within the authorities in the APDCL command, namely Lower Assam Electricity Distribution Company Limited, after the disciplinary proceeding by the order dated 02/03/2009, by order dated 31/10/2008, imposed the penalty of dismissal from service on the petitioner. Next. Against the said penalty, there is 31/10/2008, petitioner preferred an appeal on 06/11/2008. And the authorities in the APDCL by office order dated 02/03/2009 reduced the penalty from dismissal imposed upon the petitioner to compulsory retirement from service with pension benefit partially modifying the earlier punishment order dated 31/10/2008 from compulsory retirement. However, on approach of the petitioner, the respondent authorities in the APDCL by the order dated 12/12/2011 refused to grant him the benefit of gratuity with his pension benefits, holding that the gratuity is not admissible as per Rule 40 within bracket 1 of the liberalized pension rules under the CCS within bracket pension bracket close rules 1972. And in that figure, passed an order accordingly on 12/12/2011. The same was challenged by the petitioner in writ petition 883/2012. And the court, after hearing the parties by order dated 26/11/2015, allowed the said writ petition, setting aside the said order dated 12/12/2011 of the respondent APDCL refusing to grant gratuity to the petitioner along with his pension, as it was passed without giving any opportunity of hearing to the petitioner. Remanding back the matter again to the respondent APDCL to take a fresh decision regarding entitlement of this or regarding entitlement of retirement gratuity to the petitioner, giving him an opportunity of hearing. Next. Thereafter, the respondent authorities in the APDCL, while office order dated 03/03/2016, passed an order granting gratuity to the petitioner with effect from 10/02/2016, and it was paid to him on
5th April. That's right.
05/04/2016. The petitioner thereafter submitted a representation before the respondent authorities in the APDCL for the delayed payment of interest for his gratuity. And as the respondent authorities did not pass any order on said representation, petitioner on 31/0, petitioner preferred another writ petition being WPC number 3328/2016, claiming interest on the amount of gratuity that was released to him on 05/04/2016. Under the provisions of Rule 68 of the CCS within bracket আগত the CCS লিখিত Central Civil Service বুলি লেখাত সুবিধা হ'ব। CCS or জায়গা Central Civil Service Pension to bracket rules 2007. ইয়াৰ পাছত তুমি সব CCS কৰি দিবা। By order dated 31/01/2019, while disposing of said writ petition, the petitioner WPC number 3328/2016, the court directed the respondent authorities in the APDCL to consider the grant of interest on the delayed payment of gratuity paid to the petitioner. By passing a necessary order by the authorities in the FPDCL as to whether to grant interest or not, by taking into consideration all the relevant factors in that regard. And to exercise the undertaking by the authorities of the FPDCL within a period of 4 weeks from the date of receipt of the representation that may be submitted by the petitioner, after according him a hearing in that regard. Mr. Chaudhary, after this order, when the petitioner was heard,
The speaking order on 6th April 2019, my lord.
Where is it?
That page 35 of the speaking order itself, my lord, of the writ petition. Very first paragraph, my lord. The Gogoi was also heard in person on 6th April 2019. my lord.
In terms of the said order of the court, dated 31/01/2019, passed in WPC number 3328/2016. And after hearing the petitioner on 06/04/2019, the respondent FPDCL wide number MD/APDCL law cell LROC capital /28/2012/235. After hearing the petitioner on 06/04, by order dated 10/04/2019, considered to pay interest for the delayed payment of gratuity to the petitioner from 10/02/2016, either date on which from which the APDCL decided to grant gratuity to the petitioner, to 05/04/2016, either date on which the gratuity was actually paid to him as per applicable rate and relevant rules on the amount of gratuity that was paid to the petitioner in 05/04/2016. Being agreed with the same, the petitioner preferred a representation before the authorities in the FPDCL on 29/04/2019. Claiming interest, the amount of gratuity that was paid to him on 05/04/2016. Amounting to rupees 2,50,000,000. However, by filing affidavit The respondent APDCL rejected such claim of the petitioner regarding the amount of delayed amount of interest towards the payment of gratuity beyond the period from 10 to 2015. From the order, hence this writ petition by the petitioner. Directing the responding authority to dispose of the representatives of the petitioner dated 29/04/2019 within a specific period as per Rule 68 of the CCS Pension Rules 1960. Filing an affidavit in this proceeding will follow. From the order dated 31/01/2019 passed in WPC number 3328/2016 within bracket Tekiba, Bhuvan Chandra Gogoi versus APDCL and 4 others bracket close. Italy says for you. Petitioner hearing. No, but it was preferred by the petitioner. Copy of which has been annexed to this petition as annexure 4. It is seen that the court considered the provisions of section 4 within bracket 1 and within bracket 6 of the Payment of Gratuity Act 1972, as well as the relevant provisions of Rule 68 of the CCS Pensions Rules 1972 pertaining to the grant of interest for the delayed payment of gratuity. A delayed payment as well as the provisions of the Payment of Gratuity Act 1972. Including section 4 of the said Gratuity Act. And came to the finding that gratuity is payable to a person as a matter of right, who had rendered continuous service for not less than 5 years, upon his superannuation or retirement or resignation or on his death or disablement due to accident or disease, but it may be forfeited wholly or partially if the termination involves activities mentioned under subsection 6 of section 4. The court found in this order, the court found that if an employee, this is order paragraph 4, if an employee is terminated from service on the ground that he committed an offense involving moral turpitude, which was committed in course of his employment, the right to get gratuity ceases to be vested right and becomes a matter of discretion of the employer concerned to grant. Full stop. In other words, authority may withhold payment of gratuity wholly or partly, depending on the circumstances of a case, in respect of an employee whose service has been terminated on account of commission of an offense involving moral turpitude. Next. The court found that the petitioner was imposed with the punishment of compulsory retirement on the ground of moral turpitude. Court found as such, by the said order dated 31/01/2019, the court expressed the petitioner did not have the right to claim gratuity as a matter of right and could get it, if offered by the employer, hence payment of gratuity was not due when he was compulsorily retired, but it became due only from the date when the employee decides to grant it. Next page. Further, by order that such and such, the court also found that the respondent authorities in the FPDCL did not initially grant gratuity at the time of compulsory retirement of the petitioner, and to that extent, it was refused. But the respondent FPDCL decided to give the gratuity only when the court interfered with the order of the court, with the order dated 12/12/2011, rejecting the payment of gratuity petitioner, but order dated 26/11/2015, passed in WPC number 883/2012, that was preferred by the petitioner. The court also found that there was no specific direction by the court in the order dated to grant gratuity, and as such, by order dated 31/01/2019, the court came to the conclusion that the gratuity was not due to the petitioner at the time of compulsory retirement, and therefore Rule 68 of the payment of gratuity is not attractive to the case of the petitioner, as he did not have a vested right to claim gratuity as of right and gratuity was granted to him at the discretion of the authorities in the respondents APDCL in terms of subsection 6 of section 4 of the said Payment of Gratuity expiry. The court, by the order at the 31/01/2019, specifically found that the petitioner did not have a vested right to claim interest on the delayed payment of gratuity, as it was not within due when he was compulsorily retired, where subsection 6 of section 4 of the said Payment of Gratuity Act indicates that it is the discretion of the employer to grant gratuity only or partly, and it shall be also at the discretion of the employer to grant interest for the delayed payment, for which there cannot be any specific writ of mandamus. So, mandamus issued directing the respondents to grant of interest on the delayed payment, which, however, will be within the wisdom of the respondents to grant the same if the petitioner so makes a request to the respondents for the same or equally. Though the petitioner, in terms of the order dated 31/01/2019, passed in WPC number 3328/2016, made a representation for the delayed payment of gratuity to him from the date of his compulsory retirement, with effect from 31/10/2008. But the respondent authorities in the APDCL decided to grant him such delayed payment of gratuity, interest on the delayed payment of gratuity, only from the date it was given effect by the respondent APDCL on 10/02/2016 to the date it was actually paid to him on 05/04/2016, as noted above, by order dated 10/04/2019. On being inquired, Mr. Hazarika and counsel appearing for the petitioner submitted the petitioner did not prefer any appeal or review for the appropriate forum with regard to the order dated 31/01/2019, passed by coordinate bench of this court in WPC number 3328/2016. As such, the finding of the court, as such, dated 31/01/2019, passed in WPC number 3328/2016, regarding the date due from which the interest on delayed payment of gratuity left with the department and not from the date when the petitioner was compulsory retired. Remain intact and attain the finality. For the reasons above, the court did not find any illegality to the impugn order number MD/APDCL law say, /28/2012/235, dated 10/04/2019, whereby the petitioner was granted the interest on the delayed payment of gratuity to the petitioner only from 10/02/2016 to 05/04/2016, as per applicable rate and relevant rules on the same amount of gratuity. Okay. This petition for the reasons above stands dismissed.
Deeply appreciated.
This is 2019 matters. Is regarding transfer. That what I was just suggesting, my lord, to your lordship's previous, my lord, order dated 19/6/2023. Maybe retain, my lord, and if they want to transfer the petitioner, my lord, they can follow the rules and do it, my lord. Now the elementary and secondary school teachers, the transfer and posting rules is there.
Yes.
I'm suggesting him this, my lord. Because
What is the
otherwise-
instruction?
I don't, I have to file a petition, I could not, my lord. I have. We didn't do. After 2 weeks, my lord, I will.
And the person who was transferred, my lord, in his
Even
place, he has been
2019 matter.
order dated 19/6, my lord.
See, the court very specifically passed an order till you file an affidavit, status quo will remain in force. So let.
no, within 10 days,
Is there
my
any
lord.
meaning in this particular?
I'm sorry, man, extremely sorry, my lord. Within 10 days, my lord.
Now give us a date. We'll accordingly consider.
There's nothing remains, well, a person who was,
See, we do not want to review at this
No, no,
stage
that's
because
all.
that status quo order is there, let it continue.
Yes, yes.
10, my lord.
You will file your affidavit by 10th. Sure. Heard Mr. Bijidas, Lanet Senior Counsel, assisted by Mr. D. Thousand, Counsel for the petitioner, and Mr. A. Kanikar, Lanet Standing Counsel for the NHABC. Sorry, NCHS. Sorry, Autonomous Council. By order date 19/06/23, the court came to the conclusion as the petitioner is serving, is continuing, petitioner is continuing in her service as an assistant teacher graduate at Maibong Higher Secondary School, the status quo in respect of her posting at Khartoum High School shall be maintained till an affidavit is filed by the respondent authorities in the NCHAC and accordingly fix the matter today. Considering the fact however, it is found that no such affidavits have been filed by the respondent authorities, affidavit within bracket small s given by the NCHAC authorities. On instruction, Mr. Kanikar, Understanding Council NCHAC submitted that such affidavit in terms of the order of the court shall be filed. Order of the court shall be filed on or before 10th of August by the authorities of NCHC, respondent authorities NCHC. On or before 10th of August 2023. Such affidavit shall be filed by the respondent authorities on the NCHC by having a copy of the counsel for the petitioner. Thereafter, the petitioner shall file her reply, if any, if to advise, on or before 19/08/2023, list on 24th of August.
24.
Till
Sir,
Interim will continue.
Developers.
yes, Mr. Dutt.
Well, the petitioners, your lordship, my lord, basically, my lord, they were working, my lord, as my lord, appointed on my lord, temporary basis, casual basis rather, my lord. And my lord, they have been discharging their duties. My lord, petitioner one, for example, has been worked for more than 30 years, my lord. All others have, my lord, worked for more than 10 years. Now, my lord, what they are being paid is a salary of, my lord, a wage of rupees 2,000 per month, my lord. That too is not being paid regularly. In fact, the department has admitted that, my lord, that 1,60,000 and odd is still due, my lord, for the earlier years. Now, my lord, our basic case is that, my lord, though some of the appointments, my lord, where in the appointment letter is referred as part-time, we say, my lord, that whatever duties we are performing are, my lord, full-time duties. And, my lord, if the lordship sees the appointment of the petition number 1, my lord, there is no reference that his appointment was part-time at page 15.
So you are claiming wages in terms of the order of the division bench in Upenda's case?
Upendas, my lord, otherwise, my lord, but learned friend is saying that it's not covered, but we are not covered by Upendas. My case is that at least some minimum wages should be paid, because 2,000 is too paltry.
So, according to you, whatever is entitled under the minimum wages.
Minimum wage, at least the minimum wages, my lord, at least.
What is your stand, Mr. Goswami?
Yes, my lord, in fact, my learned friend on behalf of the petitioner has sought for the benefit of the judgment of this honorable court, my lord. And my respectful submission with regard to the same, my lord, they are not entitled to the same because
But
they
whether
are.
they are entitled for the minimum wages act or
Yes,
not?
my lord, as per the wages, my lord, as per their entitlement, they will get, my lord. Not that,
Now, after the division bench judgment,
my lord,
in the case of Upendas,
my lord.
probably finance department have issued a notification fixing the minimum wages, right? Giving effect from which date?
That is from the effect of my lord.
No, that is the core issue, my lord.
Mr. Borpojari, prior to that, prior to issuance of this particular notification pursuant to the order of the court in the case of Upendas, there is also, because time again and again, the finance department are fixing the wages. Because sometimes there is a claim from the tea community, the steel laborer communities and others. So you have been issuing some notifications from time to time, fixing some the minimum wages. So if the petitioners are serving, then they will be entitled for whatever wages you have fixed from time to time under the Minimum Wages Act. Are you aware of all those notifications?
Yes,
There are
there is one
notifications.
notification 2022, 21.
That is after Upendas, prior to Upendas.
My lord, prior to Upendas also.
There are all such notifications issued from
My lord.
available.
My lord.
When the, my lord, that wages concept does not come, my lord. This is minimum salary.
Minimum salary in terms of the judgments of the
Yes.
apex court,
Yes,
considering that
my lord.
aspect.
Yes.
So,
Wages and salary, my lord,
but otherwise,
my lord.
even if we do not consider the judgment of the apex court or the Upendas case,
Yes, my
in
lord.
your case of the petitioner,
My lord.
you are bound to pay them in terms of the minimum wages.
Yes,
Act.
my lord.
And that
In that case, my lord, the appropriate.
notifications of the finance departments are clear.
My lord. And who will be the appropriate?
You are reading the
authority
last
to matter?
notification.
Yes, post Upendas, my lord, post Upendas, my lord.
Finance Department had issued my lord 3 respective notifications. And the last notification that is holding the field is my lord dated 3rd of October 2019. There, my lord, the contract has been fixed that my lord fixed wages public remuneration of rupees 15,900 with year's allowance will be admissible, which will undergo revision whenever pay scale changes.
So that's true, but prior to that, you have also issued notification. Prior to the judgment of the apex court and the Upenda's case, you have also fixed the wages under the minimum wages. That's for all the tea laborers as well as the other laborers.
But perhaps my lord, in consultation with the labor department.
True.
Yes.
I'll have to find it out. But those notifications are not general notifications. my lord. Those notifications pertains to my lord, specific my lord, category of employees.
Exactly, under the minimum wages act.
Yes, because my lord, in tea gardens, my lord, the quantum will be different.
Different, that's true. But you have been issuing
Yes.
not only for this purpose of tea laborers, but also for the other departments.
In fact, by the
Because,
labor,
to my knowledge, there are notifications for the PWD and other departments. This is water resource. So same notification will be applicable, whatever was applicable for the PWD and others.
But that judgment will not come.
No. Why you are saying that Upenda's case will not be applicable?
Because this is a matter of granting salary, minimum salary, not wages.
But you are bound to pay minimum wages, sir.
Certainly, he is getting, my lord. Not that they
Are
are
you
not
sure?
getting. No, minimum wages, no. I am not referring to minimum wages, my lord. He is getting, they are getting, my lord, the amount that can be paid by the division office, my lord.
True. That is the why the finance department has fixed the minimum.
Yes,
wages.
and that is why last
Normally
occasion,
what happens
that is
is-
why, my lord, last occasion, this honorable court was
We
pleased
used to
to.
see all these notifications in the
Yes.
newspapers, right, from time to time. And it will be very small in letters, you have to put your magnifying eyes to get it. But it is very much published in the newspapers and it is a finance department.
in fact, the labor department has one notification which is with me, 27th of April 2023, where will a different scales have been.
Try to find out the other notification. Labor department is a party here.
No, labor is never not a party, because we are not like.
Difficulty, as we said, we have taken a decision that only on the basis of an application filed by the weekend. You file an application for implement of labor department. You'll ask them to give all the notifications.
I'll do it.
From the date when you have served. It will cover. When?
Well, let me give, come in 2 weeks time. To come.
Any implement petition, you need 2 weeks
They have
time.
to come
Mr.
from a
Dr.
Hailakandi, my lord. These people, my lord. Lordship knows their financial conditions and all, my lord.
If it is Hailakandi, we will say something.
That is
Give
it.
us a date by which you'll file.
My lord.
Give us a date. So accordingly, we can fix it.
Yes, madam. Lordship, my lord, today is about 27. Lordship will grant me time, my lord. By 10th, I'll find out.
By 10th?
Yes, madam.
But Mr. and Dr. Counsel appearing for the petition. Mr. Abhi Goswami, Additional Advocate General Assam. Assisted by Mr. What is name for the Water Resource, Respondent Water Resource Department. And Mr. R. Barpozari, Standing Counsel Finance for the respondent number.
You are substituting in place, my lord. That's one of 5, my lord. 4.
Last occasion.
4.
As respondent number 4.
And the administrative department has filed the affidavit, madam.
Mr. Doctor, what you will do? Implement the both finance and the labor department. This order of the court is after the decision taken by the full court.
Yes.
So that is why probably the name of the respondent number 4 is not there in the cost.
In fact, I had given him a lot cost title, my lord, amended cost title also. That's why it's not record. Oh.
Without the application.
My lord, I'll file.
You file the
I'll file
application,
both of them.
including both.
Sure.
Okay.
Lordship.
Also, for the finance department, respondent delegate, finance. During the deliberation of the matter, on instruction, Mr. Dr. Counsel appearing for the petitioner, petitioner sleeping. Wait for some time to file appropriate application or implement of finance department trusted, as well as the labor department trusted as respondent numbers 4 and 5 in the present prospect. Prayer allowed. Such application for implement Finance and Labor Department, the state filed by the petitioners on or before 11th of August, serving a copy of the same in the council for the response. You file a copy on the Labor Department.
Yes, sir.
Mr. Hazarika, are you there? Will be Mr. Hazarika, for the Labor Department, is there any separate standing council or you accept the notice? So
I'll serve.
list on 17th of August.
Biplab Raj.
Mr. Mahanta, just a minute. We'll come back to you. The morning, Mr. Khatanier made a mention regarding a personal appearance. Which item, Mr. Khatanier? Item 15. Item 15. Just tell us.
Then if it will file the person. Isn't it?
Lordship, the affidavit has been filed, Lordship. I have received the copy today, Lordship.
Just a minute.
Lordship. Oh.
Yes, Madam is the director. See, Madam, we do not want such officials to be in the court. But what we have found, we have passed this order earlier on 17th of July because there was no compliance of the order of the court passed earlier on 10th of March, 26th of April, and 3rd of May. And difficulty is we see when a person retires and not getting the pensionary benefits. It is difficult for anyone, any such government employee. That's why we have been compelled to pass that order for your personal appearance. You just see, only because of such personal appearance, affidavit has been filed today. So indeed it indicates what? That the authorities are not giving any heed to the orders of the court. You have a huge battery, large number of employees are serving under you. Definitely it is not possible for you to look in every case, but at least you have to tighten up your employees who are working under you. Here the petitioner when did the petitioner retire?
2012.
Today in which year? Just imagine the plight of the petitioner. Earlier occasion, the pension rule says 6 months prior to the date of retirement, pension papers will be made ready. We have been consistently indicating the standing councils of the Department of Education that every year, the beginning of the year, they should make list ready each of the districts with regard to the teachers and the other employees retiring in that particular day. See, what will happen if somebody retires by 31st of December 2000, whatever is the year, by the 31st of December? If he is not communicated earlier, how will he submit the documents? And you see the pension, in the pension, there is large number of documents is required to be signed. It has to be attested. In a particular order, in fact, Mazumdar, I don't know if he's aware or not. The old cases are there where the chief secretary of the state filed an affidavit that henceforth there will not be any delay regarding the submission of pension proposal. So all the pension documents will be made ready as per the pension rules 6 months prior to the date of retirement. It was an affidavit filed by the 6th Secretary. It's a reported judgment passed by my Lord Justice B.K. Sharma as he was then. And huge amount of cost was directed to be paid. Now, if the court ultimately finds that for the delay of payment of pension to the petitioner, interest is required to be paid, from whom you will collect? You cannot pass any such order of payment of interest for the delayed payment of pension from the public exchequer. For the fault of few officials under you, why this amount has to be paid from the public exchequer? We have been asked very recently, maybe beginning of this week, some interest to be paid, that means it has to be paid from the public exchequer. People who are paying tax, from a poor farmer to the richest of the richest man, why they will pay for the fault of the employees under you? You have to collect that interest from those persons who are responsible for such delay. These are the difficulties. I don't know whether you have been communicated by the standing councils or not. We have been showing this and bringing it to the knowledge. Very recently, was it elementary or secondary? I think it was secondary.
Yesterday,
Day before yesterday.
yesterday.
Not yesterday. Day before yesterday. Not
Day before
yesterday.
yesterday.
Day before yesterday. A teacher who retired long back and was kept under suspension for 8 years. Now he is not receiving his pension because the period of his suspension of 8 years not regularized. He retired during the suspension period and he was suspended for 8 years without any disciplinary proceeding, without issuing any so forth. Just the inspector of schools passed an order, placed him under suspension. Now what will happen? 8 plus 5, I think so. It has 8 plus 5, 8 years under suspension without any disciplinary proceeding, without any so forth. Now it's more than 5 years that he has retired. What will happen? First of all, you have to now take a decision that entire period of 8 years during suspension should be considered as on duty. Again, without rendering any service, he will be paid from the public exchequer. Now, pension, whatever is there, will be entitled for interest. Again, on the public exchequer. All of us, even you have to pay that part while paying tax. So who is responsible? Unless you tighten up, nothing will happen, ma'am. And we understand that you have difficulties to look after all this, but you have people in your department. Either they are sitting idle or something else is happening. Or maybe because of certain, as we know, we hear commonly when you go all the sides.
This particular case, Malak, she has something to say regarding this particular case. I was asking.
No, we'll hear you, but thing is this, we do not want you here. We have lots of work in your office, but in these kind of nature of cases, in spite of 5-6 dates are given and the affidavits are not filed, we have no other reason I have to compel you to call you. So it's better if you can put someone in the office of the education department here in the court who will take note of everything. Some will come in the afternoon, will know what are the orders passed. Their councils will let him know, and he or she, whoever, and he'll indicate to you that these are the passed where you are required to file an affidavit and what instructions you have to be given. You have to do something. Earlier, there was a process like that.
There was some sort of a miscommunication. We did not give she was not in knowledge of the earlier orders. And another thing that had happened is, for this particular case, there were attempts going on to have the pension released. The process was on. Now, once we come on with an affidavit saying that we are trying to give it is almost like considering the case some other matter comes up, we will not be able to withhold it. If we now, in our records, we were not in a position to deny the claim. So what the affidavit that has now come up on record, Lordship will find that we have taken the steps, and there was a criminal case which was being faced with the petitioner for which we could not actually get
finalize the pension.
Then now, my lord, at this stage now, the pension has cleared the pension papers. The petitioner would be getting the pension.
See, that is why
the only part which remains is the subsistence allowance, the balance of the salary during the period of suspension minus the subsistence allowance. That 50% and 25%, 3 months 50% and the 25% other part. Only that remains. Otherwise, they have cleared the dues. In this particular case, the criminal case was a hamper.
If the person has retired in 2012 and the criminal case is pending, what would happen? At best, if you have not initiated any disciplinary proceeding against him, you are bound to pay him the provisional pension, which you could have
Provisional
recovered.
was paid. They wanted the finalization of the pension, the repetition. Provisional was being paid. They wanted finalization in the repetition.
At least during this period, when the court was asking you to place the relevant instructions, you could have placed that.
The instructions could have been placed, but perhaps there was a.
That's how.
Once we concede that something comes up, we will not be able to.
At least the petitioner was receiving his
provisional pension. Yes.
That could have been sufficient.
Yes.
That was not placed before the court.
That was placed before the court. Those instructions were placed.
Last occasion when we passed this order, there was nothing before the court. Otherwise, we would not have passed such orders.
Only for the relaxation part, my lord, the affidavits were required to be filed. That is where we failed, my lord. We failed to communicate it.
And see, madam, here is also a case where the petitioner was placed under suspension and no disciplinary proceeding was initiated. He was paid subsidies allowance, and later, after 5 years, 6 years, you have regularized his period under suspension. Who got the benefit? A teacher is for the students. He was sitting idle at home or doing something else, was getting his, might be teaching, he was taking tuition, he was getting his salary. And from the public sector, the money that all the taxpayers are paying. Just borrow naam to likh it. Okay, we'll pass the order. We have a full court meeting at 1:15. We have to rise. And we'll pass the order. Until further order, your personal appearance will be dispensed with. Madam, please look into all these affairs. To talk to your standing counsels, they will let you know what are they happening in the court, what are the difficulties, and why such orders are required to be passed. Particularly, it is not much in the higher secondary. Sorry, it is in higher education, mostly in elementary and secondary. And we have also found some high-handedness on the parts of the inspector of schools or the DIs or the BEOs. DOs, what we have found, they will place the person concerned or a teacher under suspension. But I don't know to what extent. In the office order, there will be wrote that it has been informed to the directors. But to what extent you are aware of those facts, we do not know.
They have now prepared a list. They now
So
have
you
a list
have to see Mr. Khataniar. In fact, we are insisting on Mr. Khataniar. He told us there is no such disciplinary proceeding pending beyond 3 months where a person has been placed under suspension. But we don't know to what extent it is correct. So kindly see to that. And Mr. Mazumdar, bring it to her notice, at least with regard to our service manual. That we are saying the much prior to the Ajay Chaudhary's judgment.
Yes.
Our service manual in 81 has brought into record that if a person is placed under suspension, why the review is required, the 3 months, and if no suspension, no disciplinary proceeding has been initiated, what has to be done? Brought into the notice, at least she will be able to aware the other person serving in the department in her department.
Now, my lord, perhaps there's a proposal to put up, or I don't know if it has been put up, the service, there's a review committee which will go through each of the suspension cases to have it reviewed.
Ultimately what? Your review will reappoint, reinstate them in service, right? Regularize the suspension. Who got the benefit? Is the students got the benefit or public? Who is a loser and who is a benefit?
Actually, the statement a few days ago, I saw in the newspaper. the state
Advise her
is putting
properly.
up a
Mr.
inquiry.
Majumdar, I'll just say advise her properly. Mr.
I'll-
Khatania, look into all these aspects. You should have a direct contact with the standing councils, not through.
We
via
have
media.
it, we have it. And that's-
And at least you should know.
that's it.
And they put someone, some good officer for your help so that you can get the orders of the court immediately. Seventh.
Seven. That will, my lord, no, is it, my lord, on 8, my lord?
It we have already fixed last, no, ninth.
Oh, no, 9, my lord.
Okay.
So 6, my lord, there is a meeting, my lord, in
Okay, on
Kokrala.
9.
Made worship is 439 bill application. Similar matter, already two petitioner.
Yes, Mr. Goswami. You have a case diary.
Yes, we have the case diary. On the last revision, we have furnished to the order. Which is already get. We put that in ASEAN.
We have the orders.
And out of that matter, the EIP has been conducted with there are 3 victims matter. 2 victims matter EIP has been conducted and they have identified this petitioner and also the other accused. Now, matter another round of EIP is left, matter which will be conducted by.
Now just tell us two more
one
things.
victim, matter.
One Asia Begum,
Asia Begum.
whether identified by the PIP
Yes,
officer.
yes, identified.
Lordship will be 62 days.
Hold on.
They are also identified.
Then Rajdeep Poddar.
Asia Begum was found to be.
Because the other 2 persons which have been released on bail.
Akash Ali, Rajdeep Poddar, Samsul Haq, Asia Begum.
Just a minute.
All
Just
were
a minute.
there. They are identified. One round of EIP is left, my lord. So, my lord, other victims which has also been recovered along with the other 2 victims.
Sunday case.
So, that, my lord, I pray, my lord.
Kindly allow
Will
the.
pass necessary order.
This petitioner was arrested from the his residence. But due to on the ground of length of detention, as to petitioner already get bail. So kindly allow the ground of length of detention. Further detention is not necessary. Today is 62 days. Petitioner is behind the bar.
The status of my lord, all the petitioners are not same. As per the also my bail order, my lord, granted, my lord.
Goswami.
Plus.
Or Mr. N. Smith. Counsel for the petitioner. Your colleague material something different in the case there. Give it to us. You have seen. Petitioner namely such and such. Filed this application under section 439 CRPC. Seeking bail in Circle CPS case number such and such. Wherein he was arrested on 25/05/2023 and is in custody since then. Petitioner earlier approved this court for his bail in State Quota Service case number 25623. In bail application number 2030/2023 and it was rejected on 22/06/2023 on perusal of the case type. This is petitioner's second bail application of the petitioner for his release in State Quota Service case number 256 of Is there any news that on the basis of a secret information from reliable source, Maruti Alto vehicle bearing registration number AS01 EC1760 that was moving towards Koprajar from Guwahati to NH27 for the purpose of prostitution and immoral trafficking of women and children was apprehended during Naka checking and got red-handed. Some of the accused persons, including the victims, emails were also recovered. From the statements of the arrested accused persons as well as the victims, the petitioner hearing subsequently arrested on 25/05/2023, who along with other accused persons of the case used to run a racket of prostitution along with immoral trafficking of women, minor children in and around Guwahati. In the case in hand, the petitioners, after collecting the victims, handed over them to other accused persons of the case, who, after their sale, were to be handed over at Kokrajhar. And he was found with huge amounts of cash and financial transactions through his mobile network. It is seen that during test identification period, the victims identified the accused petitioner along with other accused persons of the case. Counsel for the petitioner, Mr. Ran Islam, placed before the court two such bail orders, passed earlier by other coordinate bench of this court, by which two of the accused persons of the case being identified during TIP, namely Rajdeep Poddar, Nasia Begum alias Marjina Begum alias Pinky alias Amia AMIOA, were released on bail on 18/07/2023 in said Patasargo CPS case number such and such. It is seen that the investigating officer of said Patasargo cases have investigated the matter to a certain extent, and some of the accused persons involved in the case are yet to be arrested for evading, have to be appealed for evading arrest, police arrest, police and arrest. Considering the period of detention in custody since 25/05/2023, reported the review further custodial detention in national court. One lakh, two local security, one of which shall be a government employee at the status, shall not leave the jurisdiction of Patasargo CPS. Satisfaction of the judicial magistrate Gozali. shall appear before concerned investigating officer of Patasar CPS case number such and such every Monday during office hours, commencing from 7th of August 2023 for the next 2 months. WEF 0708-2023. Or till filing of the charge sheet in the case which is earlier, whichever is earlier. Shall also appear before the concerned investigating officer of whenever it is required. The documentation that are shall not leave the jurisdiction.
Hello, please.
Yeah, please, Your Lordship, my lord. In this case, my lord, earlier my bail application was rejected, my lord. My one is the medical, one main point is that, my lord, when I was on interim bail, my lord, a section 91 notice has been issued to me, my lord. On the basis of section 91 notice, my lord, although, my lord, we do the business, my lord, I, as a secretary, my lord, lower government are not doing all these things, my lord. We have given to the third party, there is an agreement, my lord. And third party has provided vehicle and others. I have produced all the driver of the, most of the driver of the vehicle, my lord. And my lord, on the basis of that, investigation has been, my lord, progress, my lord. I am fully cooperative with the investigation, my lord, in this case, my lord. This is, my lord, page 69, my lord, a section 91 notice has been issued. And on the basis of that, my lord, I take from the, my lord, FCI office all the number and, my lord, collected the driver and produced before the police, my lord. My humble submission before your lordship kindly go to the, my lord.
Mr. Goswami.
Lordship. This is a case of my lord misappropriation of my lord PDS rights and diverting to open market, my lord. Thereafter, your lordship's, my lord, finding is there, page 73.
No, we have seen that.
Yes.
Just tell us,
And-
this 91 notice probably was not there earlier. I don't know. I have not remembered.
Yes.
Now, whether it's in the case there, is it available?
19, I have not found all these things, my lord.
And you want this one back quick enough.
Do you have the original copy of you?
Yes, my lord.
Because his, my lord, statement is recorded only once, my lord, that was I found,
It's
my
a
lord.
page 71, my lord.
Do you have the original copy of you? Because it doesn't have the signature of the investigating officer of the case.
I shall produce, my lord, original, page 71, my lord. Thank you. I have a statement in the salary line.
Mr. Goswami, just pass on the case there.
Lordship.
Date and time, my lord, 26/5/2023. Original হলে photocopy, that is the original. Nothing. Monila sir, detail আছে না?
In table.
Mr. Goswami, in the earlier sets of litigation, I remember some of the councils appeared regarding the supply of this particular rice from the FCI go down to the concerned Gram Panchayats, right?
Lordship.
That's some of SMEs. Now, as per such terms and conditions of the government, they were paid in extra. Something I remember Mr. Debojit Chekya also appeared that matter, because there was a stay order passed by this court releasing of certain. Now there is a policy later on how they have to raise the panchayats, they have to manage their own supply. So accordingly, they're paid and something was done. But it's a huge racket what we have found.
Yes, sir. Lordship may find from the order of the authority, my lord. It reflects, my lord, more than 2,000, more than 1,500 quintals rice, my lord. It has not reached the beneficiaries.
But thing
Out
is
of-
this, very interestingly, what they have pointed out, none of the beneficiaries have raised any objection that they did not receive any such rights.
No, my lord, regarding the several agents, near about 35 agents, my lord, from who used to get their rice from the that they have given their statements, my lord, that
That
they have not
is-
from May they have not received the rice, my lord.
That is with regard to Namrup GPS.
Yes, Namrup GPS, and this petitioner also is linked to Namrup GPS. My lord, he also used to give, my lord, transport PDS to their, my lord,
He was the main transporter
main transporter, my lord. They were
for Namrup.
from Namrup, and also for the one another, my
What
lord.
we have seen from the records is that Lorua GPSs and Namrup GPS.
Yes, those two, these are
They used to
maintained
procure the rice together.
together, my lord.
And it is the petitioner who is to manage the transportation
Yes,
of
transportation,
rice
everything,
from the
yeah.
FCI Gudans to both to Lorua and
Yes,
Namrup.
yes. Lordship is correct.
Well, may I submit?
Now, where that rice has gone, my lord, not, nobody is telling the truth, my lord.
Well, may I submit?
And all the drivers are working under the petitioner.
Yes, ma'am.
No, my lord, actually, Monilal Saha, my lord. As per agreement, your lordship kindly go to the, my lord.
That's only an agreement.
Yes, my lord. As
But in
per,
the office
yes, my lord.
of the FCI, it is the petitioner who is to receive rice.
Because my lord, it was received by Monilal Saha, I produced that document, my lord. Lordship kindly allow me to submit, my lord. Page 28, my lord, that agreement, Annex 3.
This way, that way,
Yes, my lord.
these are the benefit, this rice should go to the beneficiaries.
Yes, my lord.
And this may not be your client, but definitely the rice was found missing.
Yes.
It goes somewhere else, right?
It has gone.
Yes, ma'am.
Somebody is getting illegal benefit from all
Absolutely
this.
correct, my lord. My submission before lordship is that.
So
my
what will happen, even if you are outside or inside, it will continue, right?
No, my lord,
So
no, my
bill
lord.
should be mailed to you.
Actually, fact is not correct, my lord. Lordship kindly got the page 28, my lord. Because I got become the secretary, my lord, in the 26/12/2022.
And it happened during the 5 months when you are the secretary.
Yes, my lord.
That is the
Yes.
finding.
Yes, my
Earlier
lord.
findings are very much
Yes, my
there.
lord.
But even during your tenure as a secretary of Lorua Gram
Yes,
Panchayat,
my lord.
it has happened.
That has been happened, my lord. I accepted it, my lord. My humble submission before your lordship is that your lordship kindly page 28, my lord, agreement.
We are not on that.
Where-
Heard Mr. Daniel B. Chaudhary,
And my lord, medical ground, my lord.
that is
Yes.
counsel for the petitioner.
And he is cooperated with the investigation, my lord.
And
He is cooperated with the investigation. He produced all the driver of the vehicle. Because Monilal Saha is doing only 10,000 rupees given to the GPSs, my lord, as per agreement, my lord. And he has put
additional public prosecutor appearing for the state.
an extra first 51 signature. So all the things are Monilal Saha. You see.
By this application under section 438 CRPC. The petitioner named Gopal Das, Secretary of the Lorua Gaon Panchayat, District Dibrugarh, is seeking pre-arrest bail. Number police station case number 38 of 2003. Registered under section 120B of the 406, of the 409, of the 420, of the 380, of the 34 IPC. Read with section 7 of the Essential Commodities Act.
Case 77, my lord. And one has been, my lord, released on bail, my lord, after perusing material. Also can page 78, only because he cooperated with the investigation. And medical gown, I have annexed, my lord.
Matter relates to malpractices and illegal acts by the office bearers of Messrs. Namrup Gram Panchayat Samabhai Samiti. And the NFSA transporters. IMSS Lorua LARUH Gram Panchayat Samabhai Samiti Limited, in which LARUAH, huh? Samavai Samiti. Purania, Dibrugarh.
Yes,
The case that illegal that there's a big racket of diversion of highly subsidized PPDS rice, the open market, which is detrimental to the interest of poor consumers, whereby the state government is supplying, the central government is supplying NFSA rice to the transporters to the various Gram Panchayat Samavai Samitis for distribution of subsidized rice to the beneficiaries of the Gram Panchayat Samavai Samiti. Case that it reveals that during the inquiry of such malpractices and illegal acts with regard to the transportation of PPDS rice as well as NFSA rice to the beneficiaries of Namrup Gram Panchayat Samavai Samiti under Dibrugarh district. The Lorua ZPSS is to procure such subsidized rice from the FCI godowns and is to deliver it to Namrup ZPSS while taking their own rice as well as the rice meant for Namrup Samavai Samiti Limited. Such malpractices and illegal acts regarding diversion of NFSA and TDPP-DS rice supplied to Namrup GPSS was continuing for long.
So received by the Namrup GPSS. We are doing transportation, my lord. And Monilal Shah put the signature, my lord. On the basis of that agreement, my lord, he is doing all these things. That is my submission. My lord.
It is seen from the case diary. Petitioner earlier approached this court. Petitioner was the Secretary of Lorua.
Case 41, my lord, that document.
Earlier approached this court. In this court for his PRS bail in the said Lorua PS case number 3, case number number of PS case number such and such. In AB number 1826 of 2023, and the court initially on 23/05/2023 granted interim bail to the petitioner in said number of PS case number such and such. In said number of PS case, later the court, after perusal of the case study by order dated 22/06/2023, rejected said pre-arrest bail of the petitioner First in AB 1826. This is petitioner's second pre-arrest bail in such and such number of years case number such. From the case there, it is seen that the arrested accused of the case
He is released on bail, my lord.
implicated
Yes.
the petitioner with regard to the illegal activities and malpractices regarding the diversion of such subsidized rice given to the beneficiaries to be distributed through concerned Gram Panchayat Samaj Samitis.
This is bail order.
The petitioner he arrested accused and other accused persons of the case. Appeared before the investigating officer of said such and such on 26/05/2023. And his statements was recorded. And admitted the fact that by an agreement, the Lorua GPSS entrusted one Monilal Shah to procure the rice from the FCI godowns for its supply, for its transportation to Lorua GPSS, which was also followed by the Namrup GPSS. The case diary reveals that most of the transporters are serving under the petitioner, and most of the transporters, including the transporters of Namrup GPSS, are serving under the petitioner. including the accused Manilal Shah. Later, the petitioner as well as the accused Manilal Shah produced some of the drivers of the concerned transporting vehicles before the investigating officer of the case. Considering the fact as available in the case that the petitioner, in terms of the investigating officer of the case, were produced the relevant documents as well as the drivers of the vehicles transporting the subsidized rice from FCI Godan to the number of GPSs as well as lower GPSs. Custody of the petition is not warranted.
Is 83 is the medical gun of my son.
1 lakh local surety. One shall be a government employee, state or central. CJM. Oh, so to the satisfaction of the concerned investigating officer. Appear before I and before shall not leave the jurisdiction. Right. Appear on or before 5th of August, 7th of August, and thereafter as and when. To reappear. Then the cost.
One thing is that my lord, he may not be available for the son, my lord, is not well. He may be outside, my lord.
7th of
Yes.
August.
Yes, ma'am. Yes, ma'am.
In this matter, I need some instruction, my lord. Can it be some other day, my lord?
On the prayer of Mr. President, council appearing for the petition. Placed after 2 weeks on a date of 2 weeks.
Obliged.
May I please your lordship? Lordship, I made a mention in the morning, lordship.
Just
I'll-
On the prayer of Miss Etalata, counsel for the petition. Matter is open for 2 weeks. Please to leave the matter and take the weeks of this.
Much obliged.
Bless.
May it please your lordship. Well, the matter relates to the payment of pension and pensionary benefits. Even the petitioner has not been paid the gratuity, not to speak of the pension. Lordship may see
Appearing for
the last order dated 14th of June. my lord.
Directorate of Pension.
They have, after this, we have verified and we have found that only the amount pertaining to GIS, group insurance, that has been paid to me. That's very good. This is an amount of rupees 50,000. No, 80,840. This amount has been paid to me and nothing more has been paid.
No, that's per pound, but the matter is pending before the Directorate of Pension.
Now, how long, my lord? Since
No, that's true. Who is
Yeah.
appearing? Who is a government advocate here? Please come forward, whoever is there.
even provisional pension has not been paid to me.
That's
A
true.
gratuity, my lord, they
But,
cannot hold back the gratuity.
That has to be paid by the BTC, I think so.
Yes. The gratuity should have been released immediately. They cannot make any deduction, they cannot hold it back.
Mr. Chaudhary, what is happening?
Lordship, here the issue is with the petitioner.
But
She is
what
not
about-
cooperating, Lordship. To sign, a few of the papers are required to be signed. She was asked to come to the school. She is not coming. Even person was sent to her house. She is not cooperating, Lordship. That's the
But
problem.
these statements are.
There's, Lordship, there is an inquiry and report is also there by the principal.
Mr. Mahanta, see, this is beneficial for all. It's a pension amount.
Yes.
No point of.
The flag mark.
No, that is
kindly
my lord.
kindly advise the petitioner. what
No,
we are
in
fixing.
my full submission, nothing of that sort has happened.
Who do not know.
Initially, when she went there, she signed everything. She signed all papers. If they had subsequently committed mistake and they won, they could have sent it to me. If they have sent it to my house, why should I refuse?
Lordship, initially,
Why should I refuse? This is my interest. If they have sent it to me, why should I refuse? Whole difficulty is, my lord, I made certain allegations against this present principal incumbent. And he is taking the revenge in this way. My instruction is this. He is to forward the pension papers in complete form. And director will pay it.
You are appearing for whom, Mr. Vora?
Principal, my lord. Well, at our part, we have already forwarded, my lord. Yes, in fact, they will revert back and again, there's the
issue is there.
It is returned by the treasury officer, why?
My lord,
Because some mistakes in the bills or something?
no, my lord, actually, during the filing of these papers, they were asked to sign some papers, the consent letters, everything. But she never turned up to the school. So since there's order of the court, so he forwarded the authorities like this.
No, if there is no signatures, nothing, how you have forwarded to the
Yes.
treasury officer?
She never come, my lord, to the school. We requested, we sent messengers to her.
No, after retirement, why she'll come to school?
Even before retirement also, she has done nothing. Everything was done by the school authority.
I am to
Even-
put my
even
signatures.
Online registration, everything, portal, whatever they have done. And the thing is, my lord, there are ego issues there.
You are appearing for whom, Mr. Guru?
Director of pension. Actually, we are not made a party, I think.
Director of pension. No, director of pension is not a party here.
Why? Ask your colleague, Mr. Mahanta, to file an appropriate application because the matter is pending before the director of pension. You do not know in what stage.
No,
Mr.
whether-
Chaudhary, one more issue, why the petitioner hasn't been paid the provisional pension? The other documents are relating to final pension. gratuity
Final
and
pensions,
others, right?
yes.
So what we have seen from this bunch of documents that you have placed before us, that the leave encashment benefits of 3 lakhs and something has been paid to her in her account. But the gratuity could not be paid because these are without signatures and something.
Lordship,
Photographs are
there
not
is
there and yes.
another instruction, Lordship, this was first received. Thereafter, on the last occasion, court directed whether why she that has not been deposited. This may be can be paid. Some of the provisional part, Lordship, that has not happened, Lord.
Mr. Mahanta, it is the letter of the inspector of school Sirang. After proper verification, what was found that rupees 3,74,591 towards the unleave encashment was deposited in the account of the petitioner. It was released by the treasury officer. But what happened? With regard to the withdrawal of group insurance saving, it was not released, in fact rejected by the treasury officer because certain signatures, certain photographs of the petitioner is required which are not available therein. So unless those signatures and the photographs, the treasury officers, it's not possible to release that amount. So her signatures and photographs are required. That was the indication made to the, because once it was not released and rejected by the treasury officer, the inspector of schools inquired into the matter from the treasury officer and found that these things are required. So which the petitioner did not sign documents and did not provide those photographs for the release of GISM. So hopefully, please kindly.
GIS has been released, my lord.
Not released, it's rejected. It is found that
Yes, no.
due to the treasury officer, due to some errors appeared in the sanction order, it has been rejected.
Whether it is group insurance or some other.
No, it's clearly written, out of which the earned leave encashment of rupees 3 lakhs.
Earned leave, yes.
74,591 released.
That
already credited to the individual account of the petitioner. Then the GIS saving withdrawal bill. GIS saving withdrawal bill of rupees 80,843 rejected by the treasury officer.
Now that hasn't paid, my lord.
Is it?
Yes, I have sent this document.
I don't know.
This
But this is
certificate, treasury officer has given this payment on 4/7/2023.
very recently, but this is a letter of June.
Yes.
Maybe
Yes,
thereafter, possibly the petitioner might have come and done it because initially it was rejected by the treasury officer. Yes, this is the amount.
Yes, this is the amount, 80,000.
After probably signing those documents and photographs, it has been released.
My instruction is that nothing of that sort has happened because he signed everything before leaving the school,
We do
just
not know,
before
but,
retirement.
This inspector of schools, after due verification, have given this report that non-signing of certain documents, the treasury officer rejected the claim of the group
Actually.
insurance.
But
that was, we will have that. Also. That was rejected in June. That's
Maybe
right.
regularized now.
Now probably it's irregular.
So that has been paid.
You file a short application for implementation of Directorate of Pension. We can ask the what is the status.
Malad,
Individually ask you to pay her the provisional pension as per her entitlement. Pay her.
Directorate of pension of your BTC or here? State. Director of, now it is, well, because difficulty is nobody has filed any affidavit yet.
Today, in fact, for similar reason, the Director of Secondary Education was there. We are indicating to Khataniar and others. It's happening so much, so many pension cases were
Yes.
found shouldn't have happened. Anyway,
Now, Lordship may direct, allow us to just add him.
no, that will do.
We'll add him, Malad.
It's not possible because what happened, there was an objection from the computer system. It's throughout the country now. So normally we used to pass an order considering certain department
Yes.
is a necessary party for adjudication, we used to direct the petitioners
Yes.
to make them party by hand. Now what happened? If we make it like this, it will happen in the bench section. So it will not go to the
system.
CST section. So there is the requires an application.
I see.
So by a final decision, it has been taken for any such implementation. It is not by the order of the court,
Yes.
but directing the petitioner to file an application. We'll be passing. So if the petitioner is not required, even the advocates can file it. No problem.
Yes.
We'll make it clear.
We'll do that, Malad. If this, Lordship may record that it is now pending
yes,
before the, in all complete form, Malad, probably they want to say that in all complete form, my pension papers are now lying in the office of the Director of Pensions. And since when it is there, if there is any indication, that should be indicated.
Heard Mr. K.K. Mahantal and its senior counsel, assisted by the non-political for the petitioner. Mr.
Lordship for 2, 5, and 6.
Will appear for one education. Will appear. Ms. Sahari, Learned Standing Council, Department of School, Secondary Education. For the respondent number 1. Mr. B. Chaudhary, Standing Council, BTC. For the respondent number 2.
2, 5, and 6.
1 out of 4. 2, 5, 6, 2, 5, 6. Mr. D.K. Roy, Standing Council, Assam Higher Secondary Education Council for the respondent number 3. Mr. M.K. Boro,
7 and 8, my lord.
Council for the respondent number 7 and 8. Mr. Borua, you appeared for pension and public grievance, Director of Pension. Okay, okay. Directorate of Pension, respondent number nearly clear. From the relevant communications placed before the court by the respondents in the BTC authorities through Mr. B. Chaudhary, Standing Council BTC, it is seen that regarding the payment of regular pension proposal has already been forwarded. The Director of Pension through Kritak Gata, all capital take butter, online portal on 26/08/2022. To the Director of Education, BTC, while letter number DE/BTC/PEN, PEN, pension or pen, all P2 capital, dash 336/PT, part or PT, P capital T, dash capital Roman 1, secondary SEC, SC, S capital, Chirang, C capital, /2015/39, dated 03/09/2022, for finalization of pension of the petitioner, which is presently pending before the Directorate of Pension. It is seen that in the meanwhile, an amount of rupees 3,74,591 towards unleave encashment benefit and rupees 80,840 towards group insurance saving have been released by the Treasury Officer, Business Sub Treasury, in the account of the petitioner. After the relevant documents are submitted by the principal of
Disney Bandab Higher Secondary School.
Bizni Bandhav Higher Secondary School, Bizni District, Chirang, wherein the petitioner was serving as a subject teacher. The principal assistant being the drawing and dispersing, wherein the petitioner was serving as a subject teacher. Considering the same, the petitioner is directed to file an application for implement of Pension and Public Grievances Department of the state, as well as the Directorate of Pension, for adjudication, for proper adjudication of this case. Such application shall be filed by the petitioner when, Mr. Mahanta, on or before 11th, 2 weeks time, on or before 11th, list on 16th of August.
Meanwhile, Lordship may also say that
Pendency of this during the deliberation of the matter, it is placed before the court that the petitioner hasn't been paid the provisional pension. Pendency of this petition shall not be a bar for the respondent authorities in the petition to release provisional pension entitled by the petitioner, which can be deducted from the final pension,
adjusted,
indicating which can be adjusted from the final pension to her with due intimation to the Directorate of Pension.
My lord, my humble friend, may it be 17th, my lord.
You want on 17th, my lord. You will have it on 21st.
My lord.
Take back these documents, but Mr. Mahanta asked
Yes,
the petitioner
we'll file an
immediately. We will pass the order.
Yes.
The same date we will do that.
Yes.
Mr. Chaudhary. Yes, fine. If there is no ambiguity, release her provisional pension.
No. Oblige.
Hey, Sharma.
My lord, in this case, I am paying for 3 weeks time to file affidavit.
Earlier, Mr. Nayak took time, now you are taking time. Tell us on which date you will file your affidavit. Tell us, tell us. Give us a date, we'll fix it accordingly.
August, madam.
We'll fix it on 17 August.
My lord.
Lordship. I'm sorry, Lordship.
Pardon, Mr. DZ, ask for the petition.
17.
Earlier 2 weeks time, we granted to the petition, finance department of the state.
13.
File their affidavit, in the matter. In the matter today. However,
Response number 1, right?
you are appearing for whom?
On behalf of TNS, GMC, my lord. GMD, my lord.
GMD. Finance delinquent, GMD. The respondent authorities in the GMD have prayed some more time to file their affidavit in the matter. The respondent GMD, respondent numbers, respondent
3 and 4, your
authorities in
lord.
the GMD, respondent numbers 3 and 4 shall file their affidavit in this matter on or before 16th of August. Make it 17th of August. Serving a copy of the same on the council for the petitioner. Failure on the part of the respondents in the GMDA to file their affidavits in the matter, court shall pass. Failure part of respondent, we did decide then, court shall pass consequential order. Consider to pass consequential order. Placed on 22nd.
Obliged, my lord.
Much obliged, Lordship.
File your affidavit.
My lord.
Otherwise, we'll pass, keeping in mind that notice in this case or this. Negative for it. Failure on the part of the respondent authorities. GMD file their affidavit on or for that instance. Court shall consider to pass consequential order against daring respondent numbers 3 and 4, considering the fact that notice in this case was issued on 25/11/2023. Based on
22nd. Much obliged, Lordship.
May I please your lordship? My senior Mr. UK Nair has to leave the court. He has some personal difficulties. Kindly adjourn the matter.
I am for the respondent number 8, ma'am. Otherwise, the matter is ready. Date of birth was 14th, right? Next week or tomorrow, move to operation 17th of. That case, your lordship may fix it on 17th, 17th of August.
What's your good name, ma'am?
Eldas.
Mr. I Chaudhary, learned senior counsel, assisted by. You are appearing for respondent numbers 3, 4.
8. Vice Chancellor. For the college, my friend appears.
No, for the university who is appearing.
Mr. J. Patwari is appearing. Mr. J.
I'm for the body university.
Gogo is standing for higher education 1, 2. J. Patwari for 3, 4, 5. Guwahati University.
Yes, I'm for the body university 6 and 7. Hey, Ahmed.
6 and 7. And Mr. I Chaudhary, senior counsel, 65, for the respondent number 8. Matter pertains to suspension of the petitioner serving as a registrar of Notre University, Bodali.
What is the termination of?
No,
Termination of.
termination, sorry. Parties have already exchanged their affidavits. List on.
17th, my lord, if it is not inconvenient. Or else, my lord, 22nd.
22nd board is full. Okay, let us try on 17 itself.
17.
We have same on 17, 40, 24, same. 17.
Right.
My lord, I was out of station. A prayer for adjournment was made in the morning, my lord. I need some time because I received an affidavit that was filed on 18th. I need to get the instruction from petitioner. It's a matter where the petitioner is not provided pension because he was convicted and he served his sentence.
Just tell us from 18 to 22, how many of you are ready? 18 to 22. 18 to 22. See, item number 18 was of 2013.
Yes, my lord.
19 was of 2014.
My lord, in fact, I was.
20 is of 2015. 21 is of 2015.
My lord, the problem is, my lord, I was not in station. That's why I made a prayer in the morning. If
Tell
otherwise,
us when.
my lord,
Tell us when.
yes,
When,
on
when,
10th,
when?
10th is 10th of August. My lord has fixed it on 10th.
Obliged.
My lord, I'm sorry, my lord, we have lost the brief, my lord. It could not be traced out. And, my learned senior has, my lord, accepted to, my lord, furnish me a copy. I'll photocopy it from my learned senior's brief, my lord. Could it be after some time, my lord?
17th, let it be on 17th.
Give it to him.
I'll make the photocopies, my lord. matter pertain to promotion, my lord.
That's in
The
Mr. Roy,
Lordship.
possible, give it to him.
I'll give him. Let's go on 17.
Yes, on 17.
deeply obliged, my lord.
Mr. Nair, this is second time. Earlier
Yes, my lord.
On 15/6 also.
Yes, my lord.
Time was delayed for the same.
Yes, my lord, yes. We tried to find out, my lord, but the person is also not here. I'm sorry, my lord.
Lordship, in this case, Lordship, he has not been given the DCRG benefit, Lordship, on the ground that his total qualifying period is less than 20 years, Lordship. Now, Lordship, recently Supreme Court has passed some order, Lordship. On next date, he will place the orders and Lordship will pass may dispose of this matter.
No, one more thing, that whether for such cases,
That
the
Sangeeta Rai-
necessary application is to be filed. If the authority is concerned, because earlier there was the judgment of this court.
This is Sangeeta Rai. This case is also covered by Sangeeta Rai.
No, in Sangeeta Rai, Lordship, that's 2009 notification was declared as arbitrary, Lordship. In this case, Lordship, it's separate notification is there for workforce employees only, deduction of 3 years. But Supreme Court has recently passed some orders, Lordship, where it has been clarified that entire period has to be counted. And thereafter, another judgment came, Lordship, wherein it was held that only the deficit period will be counted. I mean, if the required period is 20 years, he has 12 years, Lordship, then only 8 years will be counted, not the entire.
Of what?
8 years of his regular, non-regularized service, Lordship, master or workers period. So,
No, earlier the division bench, after the judgment of Milo Justice Medhi,
Lordship.
the division bench have considered that as the matter.
Yes,
Right.
that was from the date of retirement.
Right. Now, this is,
No,
here
that-
the petitioner himself did not complete the period of 20 years.
In this case, Lordship, in this case, Lordship, the petitioner has already, she
I
is
have
receiving the
more
family
than 20
pension.
years, Lordship, but after
She is
deduction,
receiving the
Lordship,
family
it
pension.
became less than 20 years, Lordship.
After deduction of the.
Lordship.
3 years.
3 years,
Lordship.
that period.
Lordship.
But that is after, but in the division bench judgment, we have considered that aspect in a different way.
Lordship.
In the division bench, it was considered from
Date-
which date
date of
you will
effect,
get the
that is, as
pensionary
regard date
benefit,
of
Lordship.
effect, Lordship.
From the date of
26.
retirement or from the date of judgment. But that was the matter before the division bench.
Here, my total period of service is, Lordship, 32 years, 4 months, Lordship.
But from the date of regularization,
From
12
the
years.
regulation, 8 years.
8
8 years, 4 months, 10 days.
that is from.
I have,
1st
I
of
have
April
three
9th, date of
three pages
regularization
of
when?
services, Lordship.
2005.
These are left out.
No,
No,
Lordship.
2005, he was regularized. In
No, Thing
2000.
is this, the first notification is those who have served prior to 1/3/1993.
They belong to that batch.
From 1/3/93, some persons have been left out.
I
Yes,
am not
Lord.
left out, Lordship.
Yes.
Some persons have been left out. They again approach this court. So subsequently, they are regularized.
Not regularized. Lordship, in Upenda's judgment, their case was, dismissed, Lordship. Lordship, in
Their
2012,
names
Lordship,
have been left out
Lordship,
for
last
regularization, but they were
last
serving in 1/3/93.
last regularization was in the year 2005, Lordship. Persons were appointed prior to 1993. Some persons left, they were left out. Their cases were considered ultimately by the division bench, and it was held that their services cannot be regularized. For whatever reason, if you are left out, then it cannot be regularized.
Now, the petitioner comes under which category?
His service has been regularized in 2005. Yes, and he died in the year 2013. His wife, who is the petitioner, Lordship, she is getting the regular family pension. Now DCRG has not been released. AG has filed affidavit. There they have mentioned that as per Finance Department notification, 3 years has been deducted. So his qualifying period is less than 20 years. So he will not get the DCRG benefit. That is the only issue, Lordship.
But in the judgment of the apex court, only the part of pension was considered, but not the DCRG. Pension means whatever,
Yes,
minus
yes,
all this.
yes. Lord, that principle may be applied, Lordship. Which period is to be counted? That was for pension.
But the payment of DCRG under the act,
Lordship. No, while the PPO was issued, Lordship, AG has mentioned one line that his separate order will be passed for DCRG. But that was not passed, and recently they have filed one affidavit. In the affidavit, they have taken that stand.
No, it's true, but DCRG will come under the Act.
Yes.
If under the Act doesn't provide so, because 20 years this year, your pension has been paid, family pension is just because of the order.
But that deduction of 3 years was for pension only, Lord.
Deduction of 3 years for both pension and DCRG, both Lordship, as per that notification.
Clarify, I don't think so, because by notification, can any provisions of the Act can be considered, or it was a process of amendment? How you do it?
In the
By notification, you cannot.
No, this is not connected with the rule, Lordship. Rule has a separate procedure, but this was the additional benefit given, Lordship, by issuing the notification.
Lordship,
Otherwise, they would have never get the pension
if my
of this year.
past service is counted, Lordship, without any deduction, then my qualifying service would be, Lordship, more than 20 years, and I will be entitled, Lordship. And moreover, Lordship, I had 3 phases of services. One is, Lordship, as master on level, Lordship, which I rendered, Lordship, from 1981. Thereafter, I was promoted to the post of Chokidar, Lordship, works as Chokidar, that is on 16/7/1991. And my service was regularized on 22/7/2005, Lordship.
As what?
Lordship, as Lordship, regular Chokidar, Lordship.
Considering your period of service from when? That has to be there, that earlier you have started as a master role.
Lordship.
Then you have worked as a worker, whether combining both the service, your service has been regularized as considering as 20 years service, or for that benefit of regularization given to you on the basis of what?
His earlier appointment was prior to 1993.
No, true.
Yes.
That period will be there. That is why the reason is the length of service is considered. That's how you range in that particular seniority of the list.
Not.
Every such department prepare the list on the basis of total length of service.
Not.
In the seniority list. And as per the seniority list, their services are regularized from time to time. Whenever there was a vacancy arose, they were regularized. Some were left out because down below, though they were appointed prior to 1993. So whether the petitioner's name was in the list, wife, husband of the petitioner, considering the period he served as their MR or later part of the work, that has to be finalized, and then.
In my humble submission, Lordship will adjudicate that issues in some other matters, Lordship. In this case, only issue whether deduction of that 3 years was.
That is true. That is why the petitioner is claiming that he is having more than 20 years of service, considering that period.
Lordship.
But on the basis of what the reason is, when he was regularized, what was the period? When he was
at the time of regularization was, Lordship, only consideration appointed prior to 1993.
Find out. We'll also look into it. Because there are decisions of the Apex Court as well as our case as to when the DCRG can be paid. In fact, our division bench have considered this aspect on matter coming up from the CAT earlier. After the Central Administrative Tribunal decided against, that order was there when I forgot it was a matter relating to railway. So it was rejected by the railway, the Central Administrative Tribunal. It was decided by our division bench. Whole matters, I don't know what is the stage of.
Lordship will try to find out. Lordship.
Date may be fixed.
When do you want?
Any date, Lordship.
Mr. Nayak, give us a date.
After 10 days, Lordship.
Lordship.
Okay, on 10th.
Lordship, not on 10th, Lordship. On 14th, Lordship. On 14th or 16th, Lordship.
Lordship.
We'll have it on 22nd.
Lordship.
Flush.
I'm appearing on the Lordship respondent was 5 Lordship. Also conducting Lordship emission out of station Lordship. Kindly fix it, Lordship.
Mr. Mahanta for APSC.
Yes, ma'am.
Now just tell us petitioner is entitled for one more mark.
No,
He is claiming another
no,
one
my
mark.
lord, that is already decided in the earlier petition, my lord. Your lordship kindly that was already decided, my lord. So in compliance with that order, my lord, we have put one step ahead at the petitioner, my lord. Now, my lord, you're challenging that, my lord. If he is not agreed, then he should have filed a appeal against that order, my lord. Which he was claimed in earlier petition. He was granted, yes.
Who is representing tourism? What is your stand?
We have already filed a affidavit, my lord.
That's what I've seen.
We have,
Let us
we have a stand that now.
You said you are appearing for whom? Please take your seats.
নকৰিলে নেকি সি?
Yes, for the tourism department. Pursuant to the order passed earlier by this court in other writ petitions, as well as the apex court, the division bench of this court. Your stand at para 14, whether it's correct or not, find out. Your stand is very simple. Petitioner did not work, no pay, right? You don't have to pay for her salary, but she was deprived from her appointment illegally. And as she was deprived for her appointment illegally, appointing someone else who obtained lesser mark than the petitioner. Basically, the petitioner should have been appointed in her place on that date. So you have to determine the salary of the petitioner on the date when she joined after the order of the court, because her appointment was illegally kept away, giving an illegal appointment to one of the candidate respondents, right? So when her appointment was found to be illegal and the appointment was, the petitioner, the challenge to say the appointment was found to be illegal and accordingly directed for appointment, she would have been entitled for benefits, including the pay benefits. You did not pay, but on the date of joining, her pay would be similar for that period in which the earlier person was receiving. So accordingly, her pay school should have been, pay petition would have been there on that date, considering date of her joining, not as a fresh, but at that point of time. Find out our High Court have already passed, even Justice Punya's orders are there, who have set aside the appointment of the illegal appointment. We need to know that stand of the tourism department, find out whether correct or wrong. Find out correct or wrong. It is true, she need not work, but why? You illegally deprive her.
Lordship, may I read from
We will not hear at this stage. Find out whether your stand is legally permissible or not permissible, because decisions are there. Find out.
Lordship.
There are certain lawyers in the court who lays down the facts very well and admires by the court. One of them is Justice Mahanta. He's been talked in the bar, he's been talked in the panel of the judges. You know why? The fairness on the part of the court officer. The lawyers are also court officer. At the same time, they are also, when they are representing the departments, they have to be fair.
Lordship.
Right?
Lordship, definitely.
We will expect that the members of the bar will have such qualities. It helps for adjudication of the case.
We are all officials of the court, madam.
That is the first consideration. In fact, today we have been discussing, we had a full court. Certain issues cropped up after the closure of the meeting. It's very important. Mr. Mahanta, certain things are worrying us because I'm looking after some of the important districts. Some lawyers are forcefully obtaining orders from the judicial office.
No, my lord.
We are not saying our judicial officers
Yes.
are so clean. We are not saying that. We know what is happening. We are worried for those matters. But consistently, we've been getting the reports.
That means, I think this is a one-time benefit, my lord. In the long run, because
It's not
my lord,
possible. It's when a officer is a junior one and the technique, when a
the
judicial
shortcut
officer
method is
says,
not, my lord. Not, my lord.
Sustainable.
Not
difficult.
sustainable, my lord. Shortcut method is, my lord, always not
so
welcome.
see, when the judicial officers in a junior level, a seasoned judicial officer will not do. Now, if you go and ask Mr. Rokim Duara to do that, you will not get any such benefit, right?
Exactly.
Or
Because
any
their
other
experience,
persons,
yes.
but who are just joined or have 2 years, 3 years of
No,
practice, or 4 years
if
as
law
officer.
provide, you can force it. If
At
this
times-
is not provided by, if there is a law, my lord, clear cut law, you can, yes.
We have seen, because most of the special courts are here at Guwahati, we have been receiving complaints from the lawyers how to delay the special matters, special cases. For this or that reason, they will be filing objections against the NIA court, they will be filing objections against the special court. That is, although we know the creditability of, that is why we appoint them there, considering their
Because, yes,
creditability.
that
Otherwise,
I
there are
understand.
large numbers of judicial officers, right?
Because
But we do that, we think lots of things, we go through various aspects.
I have seen, but
You know, you are a colleague of many.
Yes, yes, yes. I have
So
seen.
it is difficult. Now, what we found that scrupulous persons, they are filing applications just to delay the matter. Very difficult. Because those judicial
Difficult
officers,
to, give the judgment, difficult, yet it will be
those
prolonged, my lord,
judicial
it will be
officers who are rendering their duties very sincerely,
sincerely, yes, my
they get a setback. Once we call as a portfolio judge, we call
my
and
lord,
discuss,
problem
they are
is this,
always
my lord,
scared.
Problem is this, my lord, we are legal advisor, so we have to give legal advice, not illegal advice. My lord, now,
Don't
my
know.
lord, some of them, my lord, already, my lord, they are as dictated by the client, they are doing. We
You are
should not.
representing the APSC cases.
No,
You
my
are
lord-
the former chairman of the APSC. The
I am
cases
not- I
are,
am not representing.
you are not representing
Yes,
him.
yes, yes.
You know the former chairman
yes,
of
I
the
understand, my
APSC.
lord.
The techniques you are using against the concerned judge. You'll be
That
very
will not
surprised.
healthy, my lord, that is, yes.
It is not he, maybe he,
My
maybe
lord,
his
my lord.
lawyers. So it is very difficult, and we know to what extent these judicial officers are working. Very
And
difficult,
they are in tremendous pressure, I know, my lord. They are in
very
tremendous
difficult. In fact, that's why we are saying that the lawyers are also court officers.
Yes, our duty is to, because my lord, the judgment, my lord, ultimately the judgment will be remain in the book, my lord, because it will be presided over, my lord. So if I get a bad order today, it will be, my lord, another 2-3 case will be, my lord, it will be hampered. So if you should set a bad law, that need to have a long lasting effect. my lord.
Difficulties is the officers who are doing their work gets a
Yes,
setback
definitely.
while they came in to tell us what to do, how to proceed now. They are telling openly, we'll write to you against the Chief Justice, we'll inform the Chief Justice of India. You are doing this, doing that. After all, saying all this, these courts will be really scared. High courts may not be, but those courts will be really scared.
Obviously, my lord.
Then what will happen? These are happening in open court. And people like whom?
I understand. my lord.
Understood.
Yes, sir.
And that's what the duty of a court officer. That's how the fairness stands. Mr. Mahanta will have it later.
My lord.
24th of August.
Organized Lordship.
Please, Your Lordship. Lordship, I'm appearing for Mr. B. Gogoi, Lordship. Lordship, in this matter, he had to leave the court, my lord. Therefore, there's some due to some personal difficulty. So, my lord, may fix this matter in the next week, Your Lordship. This matter will require some hearing, Your Lordship.
Okay, we'll have it. Madam Talukdar on 24th.
24th.
Inform Mr. Gogoi. Issue is very simple because there is already a direction from the court that needs to be complied with by the finance department. Nothing else.
My lord. Deeply obliged.
Obliged, Lordship.
Want the prayer. But Namati, interview is ready.